Hello, everyone, and thank you for joining Foley and Lardner for today's distribution and franchise webinar series titled 2020 Vision Strategies for Success. Before we get started, we would like to make a few announcements. We will be making a few verbal announcements along with digital announcements that can be viewed in the Q&A box located on the right side of your screen. Please also utilize the Q&A box to record your attendance for today's webinar. Please click Ask a Question and enter your first name, last name, and email address upon entering and exiting the webinar. This is imperative for you to receive CLE credit for attending today's presentation. You must remain on the line for the entirety of the webinar to receive credit for today's presentation. We also invite you to ask questions during the webinar. To follow along with our digital announcements, please make sure and click the Featured tab and scroll down to the bottom to see the most current announcements. At this time, if you haven't already done so, please enter your first name, last name, and email address to register your attendance for today's webinar to receive CLE credit. Please go ahead and type in your credentials in the Q&A box. Now, to review some important housekeeping and CLE information. This webinar is being recorded for post-event viewing. We will be announcing 3 separate CLE codes verbally at random throughout today's program. Please submit this code in the Q&A box on your screen, along with your email address when the code is announced. Please note that if you're seeking CLE credit in Kansas, New York, or New Jersey, you must also fill out an attorney affirmation form that is located in the survey link we will send through the Q&A box. CLE certificates of attendance will be distributed to eligible participants approximately 8 weeks after the webinar via email. We'll be sending a link to the survey for today's webinar. Please complete it at your convenience. We appreciate your feedback on today's program. You are welcome to enter questions at any point in the program through the Q&A box along with your email address, and if time permits, the moderators will answer your questions verbally. Lastly, if you have connectivity issues with your Mac, please consider watching the webinar on your iPad or iPhone. Now I will turn over the webinar to our moderators, Mike Lockerbie and Bobby Howell.
Good morning, everyone. This is Bobby Howell. For those of you who I've met at prior seminars, I'm sorry I don't get a chance to say hello in person, but I'm glad that you were able to join us virtually. And for those of you who are new to our distribution and franchise seminars, welcome. This is the 29th annual Law of Product Distribution and Franchise Seminar, and we hope that you will find the presentations today as helpful as we have been told by attendees in the past our prior presentations have been. You'll get a wide variety of perspectives and topic areas covered today, and we hope that you will be able to take what you learn and take it back to your offices and use it sooner rather than later. In addition, obviously, CLE credit is something that we can all use, and so I'm glad you can join us for that purpose as well. For those of you who do not know me, I am the immediate past co-chair of the distribution and franchise practice. Mike Lockerbie, my co-chair, will be talking with you in a second. And have been one of the hosts of this seminar for, this is the 15th year. So I'm looking forward to doing this this year virtually since we can't get together in person, but I'm very much looking forward to seeing all of you again in person next year. I'm going to turn this over now to Mike Lockerbie, who will introduce himself and then introduce our first speakers. Mike?
Thank you, Bobby. As Bobby said, I'm one of the co-chairs of the National Distribution and Franchise Practice Group here at Foley, and I work out of the Washington, D.C. office, with the operative words being out of the office these days. And in fact, we've been working remotely for 6 or 7 months now, although even before the pandemic was often on the road. Like Bobby, I'm sorry that we're not able to do this live and in person in our offices in Dallas, Chicago, Milwaukee, Los Angeles, or anywhere else this year, but long distance is the next best thing to being there, as they say. And we're glad that the silver lining is perhaps this has given more people an opportunity to attend. Those of you who were on last week for our first session may recall that one of the topics we covered was the supply chain. And although we're not going to be covering the supply chain today, before we get started, I do have some late breaking news on the supply chain, because just within the last week, Foley Supply Chain has prepared 2 reports, and these will both be downloadable on links that you'll get after the seminar. The first is called the Global Supply Chain Disruption and Future Strategies Survey Report. And this summarizes a survey that our supply chain team recently conducted. And of course, the supply chain has received a lot of attention, to say the least, during the pandemic. And we were asking companies what supply chain issues they are experiencing as a result of the pandemic and how they plan to address them. And 60% of the people who responded were at the C-suite level in their organizations, which I think says something. Just a few highlights, and again, you can read it in all of its glory after the seminar. Of the companies that have been operating in China, 59% have either already withdrawn operations there or in the process of doing so, and are considering doing that. And many are looking to reshore closer to home, often the US, Canada, or Mexico. 70% agreed that companies are going to lessen their focus on sourcing from the lowest cost supplier, and other factors are going to take on increased prominence. And then 62% agreed that a focus on just-in-time manufacturing models is also going to decrease. The second report is called Accelerating Trends, Assessing the Supply Chain in a Post-Pandemic World. And that, other than just reporting the survey results, provides some insight and guidance on the trends that the survey identified, and is based on observations and experience working with a number of manufacturing companies. It's an interactive report, and the 3 main topics that you'll see in it, number 1 is rethinking China. Number 2 is a resiliency review, and that allows you to conduct a resiliency review using Foley's online risk assessment tool to help your company identify risks and opportunities, which can be addressed through a phased approach and prioritized plan. And finally, the topic of innovation and efficiency, and the use of new technologies and business processes, all of which, of course, we've all been doing during the shutdown. Unfortunately, before we get to the substance, I also have a few housekeeping items that I need to go over. One is the issue of questions and answers. You can't raise your hand, but if you have a question, there's a Q&A box on the screen, and we will try to answer it during the presentation at some point. If time does not permit, or if you would prefer to have it answered in a more private setting, please make sure to include your name and email address. If you have any technical difficulties, refreshing the browser seems to work, and you can do that and rejoin. Alternatively, if you still have issues, please email videoconferencing@foley.com. There will be a copy of today's slides and written materials in our post-event communications, and they also will be shared in the announcements under the featured tab in the Q&A box. Finally, those of you who have been to our live seminars know that we very much like to get feedback, and we do take it into account. In the past, when we were handing out flash drives, we would hold those hostage to the survey being completed. We can't do that, but please, if you can complete the survey link that will be posted during the webinar and also emailed out after all, we'd appreciate it. And last but not least, if you're going to be seeking CLE credit, please be sure to send your full name and email address. And also there will be some times during the program where you'll need to enter some codes to get CLE credit. So with that, let's go please to the first substantive slide, I'm pleased to introduce Greg Husissian, my partner who works with me in the Washington, D.C. office, except we're not there right now, at least I'm not. And Greg is going to be presenting on the topic of seeing regulatory risk clearly, how to use a risk assessment to identify regulatory risk across your organization. So with that, I'll turn the floor over to Greg. His bio is on the website, and don't want to take time away from the substance to go over his many impressive accomplishments.
Okay, thank you, Mike. We have put together today an integrated set of presentations which are focused on various aspects of identifying and managing regulatory risk. If you're wondering why there's so many bad puns keyed into 2020, you can blame them on me. Unfortunately, I was given the task of coming up with the titles. The first item we're going to cover is kind of the glue that keeps all of the topics together, which is how to conduct a risk assessment, because we get the question all the time of, I understand compliance is important, but how do we know where we take our scarce compliance resources and allocate them? And the risk assessment is the guide to that. Every organization has a unique business profile based on the way it does business, what kind of goods it sells, what country it operates in, and other unique factors. And conducting a risk assessment is the glue that helps you determine what are the compliance areas where you most need to focus your attention. So if we could advance to the next slide. So we're going to start out covering the basics of what a risk assessment is and the various steps. Next slide. And then we're going to do that to work through with what you do with the risk assessment after you have it done. And then that's going to key up the next topics that we have, which go into other uses of the risk assessment and upping your compliance game in general. Next slide, please. So some of the key, as I said, the risk assessment is your guide to putting in place effective compliance across your organization. And these are some of the key things that we've seen that impact the risk profile of the organization. And the key thing to notice here about this slide is it's not going to be the same over time. In other words, it's not one and done, you do a risk assessment and that's that. As you have changes in the organization, like the types of goods or services you sell, how you run your business, do you have a merger? Do you bring in significant third parties like agents and consultants? Do you up your distribution game so you're working through third parties? All these things can affect your risk assessment. So if you haven't done a risk assessment in the last couple of years, particularly if there's been any major changes to your organization, perhaps in light of the pandemic even, then it might be a good idea to evaluate whether your assessment of regulatory risk is still up to date. Next slide, please. Next slide, please. Okay, and next slide. So these would work better if I had the controller in my hand, because it's set up to very nicely circle each one. So what are the steps for conducting an effective risk assessment? Again, that's going to vary based upon your organization and how you best interact with your compliance stakeholders. Next slide, please. Some of the key steps, though, that are common across organizations are, first of all, to secure top-level support. Without top-level support, next slide, please. Without top-level support, you're going to find that it's going to be very difficult to do anything with your risk assessment or even to conduct it properly. Next slide, please. And the reason is that you need top-level support to be certain you've got resources to support your compliance initiatives. You're going to need business unit cooperation, because the best types of risk assessment are done in cooperation with people in business units. You need to get them on board early, and you're going to need to secure commitment to follow through, because when you do the risk assessment, it's very, very common to find issues relating to potential problems that you see, areas where you can up your compliance game and things like that. So throughout the process, it's very important to update senior management regarding issues you might be finding, potential things that you need to look into, and again, that you're going to need to have some kind of follow-up with a commitment of time and resources for that. Next slide, please. So part of this is you need to assess the state of current compliance. Next slide, please. So in this, one of the key areas is just to think about what compliance resources and what types of internal controls do you already have in place. So one of the first things that we recommend people do when we're doing a risk assessment is they start by gathering up all the policies that they have. And sometimes it's quite illuminating, you know, when you get a policy and it looks like it was typed on an IBM Selectric typewriter, which actually happened one time recently, you realize that this probably hasn't been an area where there's been a lot of attention in the past. But again, you want to think broadly about this. You want your compliance policies, employee handbooks, any kind of vendor handbooks or vendor requirements, standard operating procedures, any internal controls, any place where you can have kind of regulatory risk that is being addressed in some way. It may even be in like accounting, you know, books and records, accuracy and accounting procedures and controls, or even if you look at like your terms and conditions that you find that you impose on people that you deal with, they can have compliance implications as well. So one of the first things we recommend is, why don't you gather up all of the compliance related resources, which not only represent what you're doing in the compliance areas, but also what are the assessments that other people have made before you regarding areas where you need compliance. Because as we're going to see later on, what is considered best practices for compliance is constantly changing, and the number of areas where people are addressing regulatory risk management is always changing as well. Another thing to consider is sometimes people will benchmark against industry standards. There's organizations out there who have published on this for like consumer electronics and things like that. There's organizations that have done that, and often companies put their compliance policies up on their websites, especially for the code of conduct, that's a very common one, or for vendor codes of conduct. So that's something to consider as well. Next slide, please. So we had here, this is a list that you're going to see again when my colleague Jen Lane Scott talks. So I'm not going to spend a lot of time on this, but often people come to us when we're starting with a risk assessment saying, we understand that compliance is unique for each company, but what are kind of the areas where you tend to see compliance policies? And what we generally tell people is, even though it's unique, most companies tend to have between somewhere around 18 to 22 core policies, and we've compiled a list of the policies that are most likely to come up at most organizations. There's more than 18 here, but these are not necessarily the ones that you would put in place, but they're at least ones to consider, depending on your unique business profile. Next slide, please. And then we also compiled a list of policies to at least consider. They may not be close to 100% like we see for the other ones, but these policies are ones that are fairly common as well. So it's a list of about 35 or 36 policies to at least consider. And if you don't have them at your organization, that may be appropriate depending on your unique business profile, but it's at least something to consider whether or not you have a gap in your compliance, because if the US government comes in and you're under investigation and they note that many of your competitors have these types of policies in place, but you don't, then that's a potential compliance gap that they wouldn't look kindly on. Next slide, please. Okay, so assessing areas of known problems. Next slide, please. Some of the, when you go into a regulatory risk assessment, you're usually not writing on a blank slate. There's usually some clues out there as to where regulatory risk is arising. Maybe your company has done a prior risk assessment, or it's done a compliance audit, or even a financial audit, which covered some problems with internal controls. Maybe a government has inquired, like you've received a Form 28 from Customs, or OFAC has sent you a subpoena or something like that. Those are certainly indications that the government is thinking you might have an issue. Many companies now have hotlines or whistleblower reporting, often on an anonymous basis. But if things are coming up on a recurring basis, or if there's been even one serious report in an area, then you might want to consider whether you need to focus on that more from a regulatory risk assessment perspective. And then also remember, your biggest asset as you're going into this are your business unit leaders and your compliance stakeholders. The people in the business are much closer actually than you are. Looking at this from a legal department or from a chief compliance officer perspective. So following up with these people as well, and also following up as you do the risk assessment with any issues that come up is very important. Next slide. And next slide. So one of the key areas is determining where are your areas or business units of high risk. So people often will ask about that as well. And again, that's going to vary depending on your organization, but you want to look at areas that have a large volume of business, areas that are known to have a little less respect for the rule of law. Often people will look at the Transparency International Index, which is aimed at corruption, but it tends to correlate very well with problems in other areas like export controls or OFAC sanctions or anti-money laundering. And then consider as well if there's been enforcement actions involving your industry. Of course, if you deal with control goods or sensitive goods, then that's going to elevate things like export controls and the OFAC economic sanctions. And then if you have a lot of reliance on third parties, especially when operating in third countries, then that's going to be an issue as well. And that's going to elevate the risk. Next slide, please. And next slide. So involving the compliance stakeholders, as I indicated, is very important. You want to get them involved at the outset because they're not just information source, although they're certainly that, but they're also a resource that you can harness. If they're on board with the risk assessment, they're going to be on board for following through with the compliance initiative, because the goal of this is not just to do the risk assessment, is to have it lead to a compliance response and to up your compliance game. So drawing on their knowledge of the business operations in the local country and the things that they're already concerned about are very, very important. They should also be, as you draw information from them, you want to be careful to memorialize that information that you get from them because it represents on-the-ground learning. And then you want them to be involved in training and following up on the compliance message going forward. So if you view them as more than just kind of a one-off and instead as part of the compliance solution, that's going to help your compliance going down the road. Next slide, please. So often people ask us about, should we do these with questionnaires? Should we do interviews? How do we gather information? Next slide, please. And the answer is going to depend based upon your organization. The advantage of questionnaires is they can be more in depth. You got a paper trail. There's something that you can gather together and use as a follow-up for compliance audit, but you can run into language issues and the quality of the response varies. Some people will take them very seriously. Other people will write 2 sentences and turn it onwards. The advantage of the interviews is it fosters a kind of dialogue. You can sit there and it's amazing how often people will start asking about, well, actually I have this issue. We've got this kind of strange distributor who seems to be paying bribes. What do we do about that? You've got the guaranteed attention of the interview subject and it allows for better follow-up. But you do need to memorialize what's going on because the whole purpose of this is to have something you're going to follow up on, including with audits. In both cases, you need to consider attorney-client privilege because it's not uncommon to find issues when you're doing a risk assessment, and it could be that they lead to investigations. Hopefully that doesn't happen, but it always is a possibility. So you need to consider whether or not you want to have an in-house attorney or someone on the outside counsel involved in the interviews if you suspect that there might be some kind of issues that can come up. Next slide, please. And next slide. Okay, so then what do you do with the risk assessment? Because again, it's you're aiming towards the goal of increasing your compliance response. Next slide, please. Usually this is involved in a couple of areas. You want to compile the results so that you across business units and for the various compliance stakeholders, so that it's in something that can be memorialized and evaluated. You need to determine whether or not there's any follow-up that's needed based upon the information that you've gathered, and then you're going to act on the results. Because what you're going to find is there's certain areas where it appears you've got a compliance gap. Where, in other words, you compare the risks that you've identified as part of the regulatory risk assessment, and you compare it with those compliance policies that you gathered back on like slides 2 and 3. And by comparing them, then you can see where there's gaps that need to be addressed and where you need to take action. Next slide, please. So we actually, next slide, have put together a sample risk assessment questionnaire. I'm not going to go through it, but if you don't get a copy of that, you should come back to us. And it focuses on multinational companies, but it goes through the type of typical questions that people would ask. So that's something to consider as well. If you fill it out and give it back to us, we can evaluate for you. We actually don't charge for that. We consider it to be kind of a follow-up from the seminar, so it's something to consider as well. Because if there's issues there, then you're going to want to know about it, because it focuses on the highest risk areas such as OFAC and FCPA and export controls and things like that. Next slide, please. And next slide. Okay, there's a bunch of slides here that you're going to need to go through quickly because I'm not going through them, but it's a sample completed risk assessment. So if you could just kind of keep flagging through them. This is an actual risk assessment with the company's names taken out. It was for a large insurance company that had OFAC issues, and it just shows the kind of breadth of that we have in these things. It covers such thing as OFAC risk factors and in the control environment. It's covering issues that we reviewed regarding the compliance risks that were not being addressed. It included the compliance infrastructure that we found was deficient at the company, the lack of support that we were seeing for OFAC and economic sanctions compliance, and the lack of policies and internal controls, especially with regard to screening for the bad guys, for the specially designated nationals. So as you can see, this was like a company that had a lot of issues. So it was a very big process for them. So, but we put this in here just to show how complete a good risk assessment can be, because it focuses not just on compliance, but on all the risks to the organization, including the infrastructure and things like that can be problematic. So then the last thing is, what do you do with the risk assessment? So if you go to the next slide, please. Again, compliance is all about identifying, managing, and mitigating risk. And this risk assessment is your guide to allocating your compliance resources effectively. If you haven't identified your risk, then you haven't put yourself in a position to address your risk. So by doing the risk assessment, particularly if one hasn't been done in the last 2 years at your organization, you can get a good handle on just how well you're addressing the unique risks that are coming up for your unique business organization. And again, the compliance is never one and done. It's not about, do I have all the compliance policies I need? It's about, are the compliance policies appropriate for the regulatory risks that this organization faces? And if you haven't done that kind of risk assessment recently, then you may find that there's certain risks that are not being addressed. Like maybe you're not addressing cybersecurity, or you don't have a good social media and email policy, to name two that have become much more common in the last couple of years. Maybe you're not protecting your data well, or something like that. So this risk assessment is going to be your guide to ensuring that your compliance is effective and it's up to date. So if you have any questions, then please feel free to contact us. My colleagues are going to be going through Other areas that are related to establishing an effective compliance program, but again, it all kind of ties back to this idea of having identified the regulatory risk that faces your organization so that the measures you're identifying are effective and are going to be addressing those risks. So I will stop there. If anyone has any questions, it was like 40 seconds. Otherwise, I will turn it over to my colleagues for the next bad pun-filled title and to address other areas of compliance.
Thank you, Greg. I'm not going to attempt to match you with puns. Instead, I want to introduce our colleague in the Washington, D.C. office, Jen Lane Scott, who's going to have to talk very fast because she's going to be presenting 20 steps in 20 minutes, the top 20 tips for drafting effective compliance policies and internal controls. So with that, I'll turn the floor over to Jen Lane.
Thank you so much, Mike. I'll try not to talk too fast. I can get a little ahead of myself. But yes, as Mike said, I am an associate in our Washington, D.C. office in the Government Enforcement, Defense, and Investigations Group. And albeit virtually, I'm very happy to be with you all here today. So let's get started with our 20 tips for drafting those effective compliance policies. Next slide, please. So to go over the brief overview, we're going to go over the typical policies, why are the policies important, why are the clear policies important, and kind of the general purposes and goals of these policies, because we often talk about compliance policies kind of at a high level and don't get really into the nitty-gritty of why we are doing this. Next slide. We are going to start with pre-drafting tips because all too often we get stuck in the trap of drafting first. However, this should not be your first reaction. Your first reaction should be gathering all of your policies and internal controls and reviewing what is already in place and what has already been done at your company. So think about the goals and the applications of the policies. The policy itself should say what the goal is, and then it should explicitly outline the procedure, so how to achieve that goal. The Office of Inspector General and the Department of Justice have suggested that compliance programs are the most important step a company can take to minimize regulatory risks. And then, of course, the U.S. federal sentencing guidelines state that an organization must establish standards and procedures to prevent and detect criminal or otherwise wrongful conduct and take reasonable steps to communicate periodically and in a practical manner its standards, procedures, and other aspects of compliance and ethics program. Now, that can't just be to your internal employees, but it also has to go outside of the company to outside agents or third parties who act on behalf of the company as well. Next, we are going to talk about getting management support, buy-in, and commitment. Thank you for flipping the slide to necessary compliance resources. So these compliance policies, kind of like Greg mentioned, cannot be effective without buy-in from the top and consistent messaging on their importance. So developing an accountability culture is going to be really key and requiring reporting throughout the company. So ways that you can develop this culture is by even rewarding the reporting. So it should not be viewed as tattling, but rather keeping the company out of harm's way. You should also track the violations to make sure that they're only occurring kind of in one-off. And it might be useful to track the cost of the violations, because this will then show both the company at large, but even specific employees, the issue of whether or not you are going to spend a lot of money on compliance programs that are then not actually effective, and then what is it costing the organization as a whole. It might also be useful to include a message from senior management at the start of the policies to help set that tone at the top to really get that investment. Next slide, please. So as Greg brought up in those in his presentation, still on pre-drafting tips, you need to benchmark your compliance best practices and policies for your industry really against comparable organizations. So some of the companies are going to need only a few of the policies, such as anti-retaliation and anti-harassment. But as I am guessing most of you will need in this increasingly interconnected world, you're going to need the FCPA, anti-corruption, customs, import, a lot of variety of different policies. So we have the core list here and the policies also to consider. that may become more impactful in the future, especially, for example, the General Data Protection Regulation, or GDPR. It's becoming pretty common, especially for companies with extensive operations in Europe. Next slide, please. So now we're a little bit out of the pre-drafting tips and into starting coordinating your compliance message. So the way to do this is coordinating your code of conduct, compliance policies, the employee handbook, and internal controls. So you can standardize the format, updates, and even the location where they are housed. It is important to not just keep that strong tone at the top that I'm going to keep coming back to, but to keep that consistently strong compliance message. Next slide. So for tips 5 through 7, you are going to continue coordinating your compliance message by establishing a global policy update to your schedule and updating the policies in reasonable groupings, meaning that this does not need to be done all at once. It's a very big undertaking to start editing or enhancing your compliance policies, or starting them from scratch especially. And it is important to make sure that you are being reasonable and thoughtful about how you are grouping the policies. So it might make the most sense to do kind of your more international facing policies all at one time and do them on subject matter chunks instead of kind of doing a deep dive into everything all at once. Next, number 6, keeping track of your versions and implementation dates. You know, version control is a very big thing for all of us. And so we need to make sure that we are keeping track of what's being edited, what is being presented, whether that's internally or externally. Number 7, establishing the policies in the standardized formats. The more standardized and user-friendly the policy, the more your employees are going to refer to it, and the more they are going to understand where it is and how to get the information they need, meaning that they're more likely to then use it and have not just a on paper effective compliancy, but actual in reality. Next slide, please. So how do you make those policies relevant for your audience? We have to make sure to keep in mind the ABCs of effective policy writing. A is for accuracy, as to the laws, relevant regulations, and firm compliance procedures and expectations. B is going to be for brevity, making sure that you know that the problems are normally not that there's an issue with the compliance policy itself, but it's rather that employees don't read them or don't use them. They might read them, but if they're not going to really get into the weeds of the policy, then it's not going to be as effective as it could be. And C is for clarity, as a policy that employees do not understand cannot be effective. So these kind of topics are going to be woven throughout the rest of the presentation, really focusing on how, so you're first now, we're in the almost drafting stage, but now we need to take these thoughts about how we make the policies relevant for the audience and turn them into writing. So before we do that, next slide, please. We still need to make sure that the policy is in accordance with all legal obligations, especially with the ever-changing legal landscape. It's very important to make sure that the policies are up to date with any new legal regime. And it may be useful to have alerts and trackers set up for different laws or guidances to make sure you don't miss an update or an important DOJ announcement or something like that. Outside counsel for that is a particularly good resource, as are just having the general kind of either Google or other kinds of legal tracker updates. You also should establish well-defined expectations and procedures. So that is within the compliance policies themselves, but also in terms of your drafting process. Next slide, please. This one I find particularly important is making the policies relevant to the audience, is giving everyone those real world examples where possible. So by providing your employees and individuals those specific and concrete examples, they're going to better understand the risks associated with violating the policy. And I do mean, if possible, including actual examples instead of hypothetical. It's a little bit of a almost fear tactic, but I do think that by providing these specific examples, you're more likely to catch their attention or perhaps catch them a little off guard to make them understand the individual and company-wide ramifications of breaking the compliance policies. So while the policy itself is the first level of defense, it's not going to stop the government from charging any violations. So by showing your employees the real harm that can be done by violating these policies, you're going to have a better incentive and a more tangible reason for them to follow them and for them to go look for the policies itself. Number 12, so we're still in making the policies relevant for audience. We haven't even got to drafting yet. Ensure that the policies are easily accessible and give contact information for the people can get more information if needed. So like Greg mentioned in his presentation, you should definitely consider posting at least some of the policies externally and conspicuously posting them on your internal sites. Now, something that is key about this, people are not going to go digging for compliance policies. They have to be readily accessible and available at their fingertips. So you'll also need to give examples to your employees of when they should be looking at a compliance policy. Why would they go there? It's kind of a nebulous term for those who are not necessarily in specific divisions that always know they have to go to their policy to understand what they must do. So we have to really give them concrete examples as to why this should be their first line of defense. And one of the ways that you're doing this is by ensuring that the policies are all in the same place and in a reasonable space. You should also consider best practices in general user-friendly guides. So are you hyperlinking them internally? Is there something external? Are you kind of posting them on the main platform of your internal intranet? There are a lot of different ways to make this kind of an easier process for your employees. And the easier it is for them, the more likely that they will rely on it and the more likely they will continue to go back to it. Next slide. So for number 13, you should consider drafting supplemental guidelines for people who are most impacted by the regulations instead of stuffing everything into a one-size-fits-all policy. So I think this is particularly important because we need to think strategically about who needs to understand what parts of the policy. Does an employee who will never engage in kind of cross-border trade or with anyone from a foreign office need to know the in-depth weeds of the FCPA policy? Probably not, but it's probably useful that they know that it exists and they know where to find it. So perhaps it could be in a more easily digestible format. There could be a high-level broad policy that says these are all of our policies in place and this is where you find them. Here's a little summary blurb about it, but then you can link it to the other policy or additional information instead of including it all in one bulky policy. I think compliance policies often tend to get very in the weeds, which is great because there are individuals who need to know that information, but that's not appropriate for everyone. So I think when you are revising or refreshing your policies, it's important to take this as an opportunity to really think about who needs to know what and whether you can limit the length of the more widely dispersed policies without sacrificing the content of them. Next slide. So now we are into actually drafting the policy itself. And one important thing to do is establish kind of a consistent and crisp, readily followable format for your policies. So you really want this to be consistent visually as well as how it is written. So you would like to get that professional font and layout. You should use boldface type or underlining when appropriate and bullets to highlight key points. It should be in a structure that allows people to readily find parts of the policy that are important to them. So for example, when you have a table of contents for larger policies, internal hyperlinking is going to be a very good tool. So, someone can come here and click directly on the word that they're looking for from the table of contents, and it takes them to that part of the policy. Additionally, just making sure that it is a true searchable PDF will also do wonders for the policy and the use of it for your employees as well. And remember, we are on step 14 of 20, and now we are finally getting ready to draft. So there's so much thought that needs to go into changing and implementing, adjusting the policies prior to the actual drafting piece. Next slide, please. Step number 15, avoid legalese. So if you can define key terms, define acronyms, and look for ways to summarize the law in plain language, you're going to get a lot more traction with your employees. The compliance policies, like I said, are often very dense, and as Greg mentioned, there can be upwards of 20, but on that list there was 35. So say you have 35 of these policies, it's going to be really difficult to get your employees who need to read the bulk of them to really get ingrained in the material when they are dense and very legally drafted. So to ensure an employee is going to read them, the focus should be on making them as user-friendly and kind of in a way as simple as possible. That means drafting them in plain English while you're doing the drafting process, or perhaps it might be easier to go back over them after they're drafted and rework the language to really make it more user-friendly and make it applicable to all instead of the kind of legal realm that we often live in. Next slide, please. So while similar step number 16 to 15, it's slightly different. Instead of focusing just on the legalese part, you really want to write in simple terms using clear language. So you should be focusing on using active voice, aiming the policies directly at the audience that you are writing for, using a consistent tone and presentation across all policies. And then this is kind of an aside, but you should really be considering translating your key policies if you have operations across countries. It's a pretty easy process to implement, and it should be something that is high on your list of priorities because it will really help, especially when it comes to FCPA and those kinds of anti-corruption policies. That would be particularly important to have translated. If it's a policy that you are going to implement and really expect those maybe third parties or vendors to know, then you should also be putting them on your websites. Additionally, maybe it would be useful for someone to have kind of a master key or like a final edit to make sure that the tone is consistent throughout the policies as well. Number 17, keep your policies as short and concise as possible. Next slide, please. So now we are into post-drafting. The policies are drafted, implemented, now what? Number 18 says that the policies, we need to ensure that the policies are actually read and that training is actually completed. So they can be incredibly well done, but they're almost, not quite, but they're not as helpful as they could be to you and your organization if they're not being read, reread, and followed. You may still get credit for having the policies in place, but other than that, it's still going to be a discretionary, act of the government to whether or not they're going to charge you with any kind of violation. So I think a good way to know whether or not your trainings were effective is to track the baseline knowledge prior to trainings. So doing a kind of knowledge check prior to the training and after the training, maybe in the middle, to see what is gained through the trainings on compliance. Additionally, you really should be keeping good records of who received a policy and who was trained for what policy through these policy certifications. And of course, making sure that this is a part of the new hires kind of human resources packet is engaging in their, whether it's all policies or just specific to what they need to know. That should be a kind of easy check mark to make sure that your new hires are engaged in the compliance of your company. Next slide, please. So number 19 is performing compliance audits to ensure that the policies are understood and actually being followed. And I believe that my colleagues are going to speak a little bit more about that after, but we need to make sure after the original trainings, you are still going through and ensuring that people are remembering, they're knowing where to get the policies still. It could be as simple as an email blast, just a reminder. It could be, again, a knowledge check or other kinds of audits. And then making sure that internal reporting or compliance hotlines are actually being used. And then, of course, having those non-retaliation and non-intimidation policies in place and having people know that they exist is also very important for people to feel comfortable reporting any kind of compliance or policy violations. And lastly, last slide, please. Number 20, regularly reviewing, so we kind of get back full circle to the beginning. Review your policies to ensure that they're up to date, and whether that's annually after major changes at the corporation, or if any feedback, internal or external, is provided. I think it's useful to review cases or settlements that are applicable to your policies and make adjustments and changes as appropriate. And also take the time to listen to feedback from your employees. They'll have the really good sense of what's going on the ground. Additionally, utilizing Foley and your other outside counsels as experts, they're going to be a great line of defense as they're looking and reviewing these changes to keep you, the clients, apprised of any new major changes. So with that, thank you very much. I will now pass it back to Mike. I hope I got my 20 in and my 20. So thank you for having me.
You did. You made the trains run on time and then some. And thank you. I see that so far no one in the audience has any questions for Jen Lane, but again, if you'd like to submit them, we can deal with them via email later. So with that, I'll turn the floor back over to our announcer.
Good afternoon. Thank you, Jen Lane and Mike. At this time, I will announce the first CLE code. For those seeking CLE credit today, please type the 5-digit code into the Q&A box with your credentials and hit send. We have also sent the survey link that includes the attorney affirmation page in the Q&A box. The first CLE code is L0GW9. Again, that is L as in Lima, the number 0, G is in George, W is in whiskey, and the number 9. It is imperative you input your email address and CLE code in the Q&A box to receive credit for today's program. One more time, that first CLE code is L0GWN. Thank you.
Thank you, Mary. Our next speaker in the compliance segment of our seminar this year is David Simon. David is a partner in our Milwaukee office and is one of the authors of a compliance toolkit that I suspect will be part of what he talks to you about in the context of discussing using compliant audits to enhance compliance and internal controls. David?
Thanks, Bobby. I hate going after the CLE codes are listed, because I know this is when everybody gets up and goes to the bathroom or goes to get a cup of coffee. So I hope I didn't lose too many of you. I wanted, if you could just move to the next slide. I wanted, before we jump into the topic, to just sort of take a half a step back and make sure that we're sufficiently emphasizing the punchline, which both Greg and Jen Lane mentioned, but I want to mention again because I think it's sufficiently important. I am an enforcement defense lawyer, first and foremost, and compliance secondary. And, you know, I think it's important to think about, there's a lot of good reasons to do compliance, a lot of good reasons to manage your risk, to identify your risk, to have these policies and procedures in place. But, you know, most importantly, I think most consequentially, is if there's a problem. And all of this that you're hearing about in this first set of sessions is really designed to put you in a better position, put your company in a better position if something goes wrong. And you are in front of the SEC or DOJ and have to justify, you know, something went wrong despite our very effective compliance infrastructure. So I think that's important to keep in mind. And as you're thinking through this stuff and listening to the presentations, you know, not a pleasant mental exercise, but picture yourself sitting across the table from the Department of Justice and being able to explain to them why your program was good and that something went bad, something went wrong despite a good program, as opposed to not having a good culture of compliance in your organization. That can make a huge difference in terms of decisions to bring criminal charges against the company, and also in terms of the fine exposure that the company is you know, subject to if there is a violation. So pretty important, I think, context for all of this. I want to talk about probably the area that is most neglected in the compliance area, and that is the sort of testing, monitoring, and detecting area of compliance. You see the slide that's up. I think John Turley, my colleague, is going to use this one in the next presentation too. This is our analogy of a compliance castle, where you have, a moat on the outside, prevention, you've got a, inner walls of detection, and then sort of your inner sanctum, which is response. Each of which is critically important. I am focusing here on the detection piece, monitoring, auditing, testing. If you do find yourselves in front of the DOJ or the SEC, part of the questioning, a lot of the questioning is going to be on, okay, good work, you did your risk assessment, which is critically important to us. Nice job, you've developed policies and procedures. They're reasonably designed to deal with the risks that you've identified. Nice work. How do we know they're operating effectively? That's the question. And so that's what I want to sort of talk about, ways in which we can answer that effectively if we're ever in that situation. Next slide, please. I just want to spend a minute, as I said before, this is sort of a neglected area for a lot of companies, frankly, because it's a little bit harder and more expensive and more intrusive than some of the other parts of compliance. But the US government has been sort of sending out a message repeatedly and more aggressively that this stuff is really important. You see on the slide here the US Sentencing Guidelines Manual, which assesses whether there's an effective there's a framework for assessing the effectiveness of a compliance program, includes the reference to monitoring and detecting criminal conduct. The FCPA enforcement policy makes it clear that you're not going to get credit for remediation unless you're auditing your compliance program. Next slide, please. The FCPA resource guide, jointly published by the SEC and DOJ, includes a set of hallmarks of what are effective compliance programs, and periodic testing and review is a key component of it. Next slide, please. A really good and useful document for compliance practitioners and professionals is the U.S. Department of Justice's evaluation of corporate compliance program document that was published fairly recently. And in this, there's some really, I think, are probing, interesting, and direct questions that these regulators are telling companies, these are questions we're going to ask you. If you are in front of us and we are probing the effectiveness of your compliance program, we're going to ask you, what have you done to measure the effectiveness of training? That's great that you trained. How do you know people are retaining it? They're going to ask you whether you've exercised your audit rights against third-party intermediaries that might get you into trouble. They're going to ask you about sufficient access to relevant sources of data that allow you to test. Are you keeping track of this stuff? We'll talk about that a little bit more in a second, but that's a question that they're going to ask. What about internal audit? Are they just checking the SOX boxes, or are they also probing organizations subject to audit for compliance with policies and procedures of the organization? And when testing, are you looking at and analyzing your data? Are you talking to employees and third parties to ensure that your policies are being followed? I just would pause on this again to suggest anybody who's interested in this topic generally, which I assume you are since you're sitting through our presentation, I would really highly recommend reviewing this document. It provides a pretty clear roadmap for what DOJ is expecting when you are in front of them. Next slide, please. Just other guidance, in recent corporate criminal settlements or deferred prosecution agreements, the DOJ and SEC very often include language obligating the company to be conducting reviews and testing of its code, of its policies, of its procedures. There are also other other sources of a duty. The direct under Delaware corporate law, there is a director's duty to monitor and oversee compliance programs, including testing and monitoring. And the COSO guidelines of the Treadway Commission also provide some specific guidance on what is expected from an internal control system in terms of determining whether it's really working. Next slide. So I do want to talk for a minute about the data and having the information you need to do testing, monitoring, and auditing. This is a big issue and a big problem for a lot of companies, and I think ought to be a fairly high compliance priority. You need to know and be able to tell, right, who are your third-party intermediaries? What agents, brokers, consultants are you using around the world to represent the company externally? What are your systems for collecting, your financial record keeping systems? I know a lot of companies, particularly ones who have grown through acquisition, have business units. One business unit's on SAP, one business unit is on Oracle. You can't always get reports of certain business activity from one business unit that you might be able to get from another, and it's hard to integrate them. This is really important, and it's a question you're going to get asked right away. If you can't access the data you need to test and monitor, you're probably going to get dinged. And that doesn't necessarily mean your compliance program's ineffective, but it may mean you need to do some extra work to make sure you're satisfying the regulators. Next slide. So I wanted to just talk briefly, sort of maybe the platinum standard for monitoring, testing, and auditing your compliance policies and procedures are some of these very sophisticated data analytics systems. And there are a number of them that are, some companies have developed in-house. You see Microsoft and AB, Anheuser-Busch InBev, both are listed there as companies that have built systems. There are also systems you can buy from third-party vendors that essentially bolt on to your SAP or your Oracle or your company systems and look for patterns that could be indicative of fraud or compliance violations or some sort of issue. I mean, that is obviously monitoring at its very highest level. It's pretty intrusive and it's quite expensive. And I think this is something that's probably limited to companies that are highly regulated in very high risk industries that have resources to expend. I want to move to the next slide and talk about some more maybe more practical ideas for monitoring compliance with your policies and procedures. So just some fairly low touch, fairly easy ways to do monitoring, ongoing monitoring. I mean, if you have third-party intermediaries, if you're doing business through distributors, which I assume you are since you're at this seminar, a classic third-party intermediary, doing randomly selected or judgmentally selected samples of your third-party intermediaries and just run them through Google. Have a compliance person check and see if they are showing up in headlines for engaging in non-compliant conduct. Are they paying bribes? Are they engaging in fraud? Are they associated with, prohibited sales to Iran? Are they fixing prices with their competitors? It doesn't take that much work, and you don't have to do that many of these to get a lot of credit from the regulators that you're monitoring. Another option is email surveillance. This is pretty common in the financial services industry, where they're much more highly regulated than in other areas. But there are programs you can get through third-party vendors that will look for non-compliant keywords, buzzwords that would pop up and show maybe communications that are problematic and elevate that to compliance. And that is an obvious and effective way of monitoring. I talked about the data analytics products before. Doing regular updates on screening on SDN lists and reputational due diligence for third-party intermediaries, doing updates on your customer list to look for potential sales to SDNs or sanctioned countries. These are things you can do. You can have a compliance manager level person do to check to make sure you're not violating your policies, and you're going to get significant credit from the DOJ and SEC for doing that. Next slide. Some other things around now that sort of monitoring. I want to talk about testing, right? So monitoring is sort of ongoing. What are we doing to check and make sure we're doing what we're supposed to be doing, whether these policies are being followed. They're also testing to see if they're being effective, if they're keeping us out of trouble, right? So, one of the things DOJ and SEC have asked about are, training, effectiveness. So, you see up here, one idea for testing is just, making sure that your training is effective by having quizzes and tests, or some way of going back to employees to make sure they understand what they were trained on. You will get dinged if you're presenting your program to DOJ and SEC if you can't answer the question of, well, yeah, you did this training, but how do you know it's working? How do you know it's effective? How do you know it's sinking in? Employee surveys, I'm sorry, I'm out of order in my bullets here, but employee surveys is another way you can test, right? You can run employee surveys to see whether the people, as Jen Lane said, the people who should know about the policies know about them. So if you have a certain job that requires you to be dealing with, exports of products overseas, you should make sure those employees are well aware of the export controls and sanction policies. You make sure all employees know about your hotline and know how to raise compliance questions when they come up. This is something not that hard to do. There are third parties that will run it for you, but it's fairly easy to do on your own. And it's a good way to it's a good way to sort of to find out how these messages are being received by your employees. But it's also a good thing to be able to show to the regulators that you're paying attention and you're testing. You can also test your procedures, right? So, if you have a compliance policy or procedure that for hiring, third-party intermediaries in countries with a reputation for corruption, that they have to go through a certain set of due diligence procedures and have certain contract language included in the agreement. You can pull a random sample or a judgmental sample of new intaken third parties and test it. You can sort of look at expenditures to see if money is flowing out to a third-party intermediary that didn't go through the process. You can check your expense reimbursement to see if meetings with government officials are getting the appropriate compliance approvals, that sort of thing. So those are ways to test and check as well. Let's move to the next slide. So last piece is auditing. So I view monitoring as sort of what you're doing as you go. Testing is your checking of your procedures to make sure they're being followed. I think auditing is a little bit different and a little bit more aggressive in that you're not just checking the box to see that the procedures are being followed, but you're checking to see that there are no violations of law. And this is an area that is a little bit harder. I think the other two there are ways to do that, sort of practical ways to do that are not super burdensome or super expensive. Auditing can get more challenging and require more resources because you're digging deeper and looking harder. Some areas I mentioned before, one of the things DOJ asks about is, are you auditing your third-party intermediaries? And this is one that's very, well known in the FCPA space is that DOJ and SEC expect you to have audit provisions on any high-risk third party that's acting on your behalf in a high-risk jurisdiction. And if you have those anti-bribery provisions, they expect you to use them and to be looking into their activity on your behalf and make sure they're not violating the law and violating your contracts. There are other things you can do, and we generally recommend trying to leverage internal audit if you have internal audit, but there are other things you can do, to check and see whether any violations of law or policy are making their way through. You can use an internal audit to look at expense reports, to look at gifts, meals, and entertainment, to look at disbursements to third parties and make sure there's nothing that's suspicious. You can conduct, as I said, audits of higher risk third party intermediaries, either internally or hire an audit firm to do that. You can, identify higher risk government contracts where maybe you had a highly regulated, maybe you had a regulatory dispute in India, or you had a big piece of government business in China that has bribery risks. You can do an audit of those contracts. You can look at all the expenditures and payments associated with it. You can look at your third party involvement. You can look at the pricing and see if you're seeing, float that could be used for bribery. Next slide, please. And these are just, obviously even more with regulatory disputes. You can look into those. You can look at sampled disbursements. One last point that's pretty easy to do here that I recommend a lot of times when companies don't have a lot of resources is to focus on a particular high-risk third-party intermediary and a particular invoice that they send you. Dive in. Don't pay it right away. Ask for backup. Look at where they're spending their money on your behalf and make sure it doesn't raise any red flags. And at a minimum, it'll show them that you're paying attention, and it will also allow you to show the regulators that you're auditing. I'm going to just put up this last slide. Some red flags. These are just things. There are auditors here, probably in the group who this is all very familiar to, but these are things to pay attention to when you're looking. Look for even dollar payments. This is pretty common. This sort of internal audit 101, but low invoice numbers, sequential invoice numbers, same address of a vendor, duplicate names, cash, payments outside the jurisdiction that the services were performed for. These are the kinds of things you want to look at. So I'm done here. But those are things, some ideas of things you can do. I forgot this last slide. I shouldn't be done yet. You got to respond too when you find these problems. That is absolutely key. You find issues in your testing and your auditing and your monitoring, and you got to go back and feed that into your risk assessment that Greg talked about and address your policies and procedures as Jen Lane discussed to make sure that you're in this sort of virtuous circle of improvement. So I will pass it back to Mike or Bobby.
Thank you, David. Appreciate that presentation. Our next presenter is going to be John Turley. John is a special counsel in our Milwaukee office and is also a member of the the compliance and anti-corruption practices. And he is going to be talking with us on the next step in dealing with the compliance program, and that's actually putting the vision into action and building an effective compliance environment. John?
Perfect. Thanks for that introduction, Bobby. It's great to be with everyone today. So let's flip to the next slide. All right, so I wanted to start this segment by just reminding you of the slide that David had up earlier about really what the compliance mission is. And that's simply that you're trying to prevent corruption, but if you do detect it, you respond appropriately. And as David went through before, listed on the screen there, you see the critical elements that form the infrastructure of effective compliance programs. These are, to use the castle analogy, kind of the bricks that companies use to build their compliance programs. And the last three segments, Greg and Jen Lane and David discuss several of these key components, the importance of conducting periodic risk assessments, the importance of developing and drafting good policies, and the testing and auditing of your program in turn. So next slide, please. But I think just as important, and maybe even more important than putting together the right infrastructure for your compliance program is making sure that you develop a very strong ethical culture at your company. And I really like this quote from Lou Gerstner, who's IBM's former CEO. And paraphrasing a little bit, culture isn't just one aspect of the business. It kind of permeates everything. And as you see in the little graphic below, it's your employees, after all, who like a few good men that are sitting on that wall and who are in charge of protecting your compliance castle from the proverbial red dragon of corruption. So that's what I really want to spend some time talking about today, and what I want to focus on in this segment is I'm going to talk about what is kind of a fuzzy topic, and that is, how do you develop an effective compliance culture? And I think the good news here is that there have been many behavioral scientists and sociologists, probably most famously Dan Ariely of Duke University, that have conducted very extensive research into the question of what motivates people to act ethically or perhaps unethically. Why do people engage in conduct that they know is wrong? And what we've noticed is over the last couple of years in particular, you start to see more and more companies that are taking the findings from this sort of academic research and using these findings to adjust their internal controls and to tweak their policies. And this process of going about and improving your compliance program by taking into account why people act like they do is now what is commonly being referred to as something called behavioral compliance. So we're going to talk about behavioral compliance today. So next slide, please. So I think a helpful way to think about behavioral compliance is to kind of go back to the traditional fraud triangle. And if you remember this from law school or from business school, the fraud triangle really has three components. It's opportunity, there's pressure, and there's rationalization. And what I think has been happening traditionally is there's been a lot of focus on at least two of these elements, opportunity and pressure. So, how do you limit opportunity for bribery? Well, you can set up internal controls so that money can't flow out. You can put in place double approval requirements. You can conduct testing and audits, as David mentioned. And for the pressure components, you find ways to kind of reduce the pressure to commit fraud. You create incentives for people to report suspicious behavior, and you reward ethical conduct. But I guess for pressure, perhaps even more importantly, is you create huge disincentives, severe penalties. You tell employees, hey, we're going to fire you if you engage in fraud, and so on and so on. Behavioral compliance, though, I think falls under this rationalization prong. And it certainly has received more attention lately because it's trying to answer the question is how was there this massive wide-scale fraud happening at places like Enron, at Wells Fargo, at Theranos, and I think exploring these types of questions is one of the reasons that Richard B. Strong's now famous compliance training video that he made for MasterCard, which I'm sure many of you have seen. I think that's why that training has won so many awards and has been so effective, because essentially Richard B. Strong just says, look, I'm not a bad person. I'm just a regular guy. I got caught up in this. And I just want to explain to you how easy it is to slip into this and how this happened to me. And really, to me, this is a little bit of a pushback against that common notion that every wrongdoer is a bad apple. You know, I can tell you, we've done so many investigations, and it becomes almost trite that you ask, how did this happen? And the answer is almost always, well, we just had a bad apple, and that's what started that problem. So I think behavioral compliance goes beyond that a little bit. So next slide. So I think to address this bad apple fallacy, there have been all kinds of experiments, but I just wanted to talk about 3 that I think really drive home the concept for me that regular good people can sometimes engage in bad behavior. And the 3 experiments, I'll just go through them quickly. The first, Dan Ariely did what he calls the matrix experiments, and he's done this many times, and the results always seem to be the same. But it's a simple test where you have a group of people, and in the control group, they come in, take a math test. And what they find is that they just do a math test, and everyone turns in their test, and they grade the papers. On average, people get about 7 out of the 20 math questions right. But what's interesting is he ran the experiment, but he said, okay, this time I'm going to tell everyone the answers, and we're going to self-grade. And then verbally, you just tell everyone in the class what you got. And when he ran that experiment, instead of the 7 out of 20, people on average got about 12 out of 20 right. Even more interestingly, Ariely put in Confederates, and the first thing he did is he's at Duke University, and their rival is UNC, if you may recall, is he had a friendly with the Duke University shirt, and the person from the Duke sweatshirt stands up and says, well, hold on, so you're not going to be testing this. I can say whatever I want, right? Okay, so I got 20 out of 20. And so you have that Confederate who says that. And after that happens, what's interesting is the results are that on average, people got 15 out of 20 right. And also interestingly, when you have the unfriendly, someone in a UNC sweatshirt stands up and makes the exact same statements, that number drops down to 9 out of 20, which is higher than which is lower than the verbal response. So really interesting to show that there's this range of willingness to cheat in certain circumstances. Another interesting experiment is the interview experiment, where you have asking people in basically 2 situations. First, you have a hypothetical interview, and you just say, okay, look, if you were in an interview and people were to ask you, if the interviewer asked you, hey, do people think you're hot? Do people think you're attractive? In that situation, 68% of the participants said, I would never answer that. That's an insulting question. It's improper. I would never answer that. But then they actually conducted the experiment. And what was interesting is that 0% objected to the question and refused to answer, but they provided some sort of answer. So there's this notion of, hey, here's what we think we would do in those situations, and then there's the reality of what actually happens. And the last experiment, which I think is really interesting, is an exposure experiment. Here, the punchline basically is, if you are in an environment where there is a lot of cheating going on, just being exposed to cheating, into bribery, into corruption, tends to cause you to cheat more. And in this experiment, they had the proctor basically says, look, I don't want to be here. You don't want to be here. You know, $50, why don't you give me 10 and I'll give you 40, and I'll just write you down as having taken the test, and no worries, no one's going to grade it or anything. And even if people rejected that bribe and went ahead and took the test, what they found were those people tended to cheat about 15%. There tended to be about a 15% increase in the amount that they cheated on subsequent tests. So again, very interesting examples. Next slide, please. So, you know, one of the questions that you have is why do good people do bad things? And you know, the short answer is because of all these various unconscious biases that you see listed on the screen. People, and we all tend to rationalize our behavior, and ultimately we may not be quite as ethical as we think we are. Dan Ariely, I kind of like this, he uses a very academic term called the fudge factor. And the way he describes it is that there are certain things that we all kind of know are okay, and there are certain things that are definitely not. But then there's that fudge factor, that creamy middle that can expand or shrink depending on various social cues. And that is the important element on the compliance front. So next slide, please. All right. All of what I've just gone through is great. It's great cocktail discussion. But really, I think what I wanted to do in the last couple of slides is just talk about how this research can be applied in practice in the compliance context. And I should note at the outset that a lot of this stuff is not hard to do. A lot of it is easy, but it can get results. So the first thing that I wanted to highlight is something that Greg pointed out at the outset, and that is that if there's not a commitment by senior management, then you're really in trouble. Academic research has shown over and over that you can have the absolute best written policies in the world, but people take cues from other people. They're not looking at policies. So if they see senior managers acting in a certain way, they assume that it's okay. The compliance ideas that we had coming out of this is first, make sure that management responsibility is clearly noted. When you talk about policies and even setting forth the policies, make sure you note that management is going to be held responsible for making sure that their reports are going to adhere to the policies. You may want to have a section that explicitly says that. When you're doing postmortem, if you have an investigation, you're trying to figure out what happened, you do a postmortem analysis, make sure you identify things that management did right, things that they didn't do right. The other interesting observation is that if you have something that's really, really important, have it sent by senior management. Have it sent by the CEO. The example that I have was one company observed that when they sent out emails from their compliance system, people were opening their emails at around 10% rate. Everyone else was just deleting them. But what was interesting is that when the CEO sent out a compliance message, they got 80% open rate. Still, there's not 20%, but there's 80%. And that's because people want to know what the CEO thinks. They want to make sure that they're following the best practices set by the CEO. And kind of piggybacking off of that point, one of the things that you can do is you should have your managers take compliance training first and then tell their reports, hey, do the training. First off, from a practical standpoint, you often hear people say, well, I was just too busy to take the training. But if they see that their manager has taken the training already and the manager is saying, I had time to take this, they'll do it as well. An interesting point on this, David had talked about sitting in front of the DOJ, is I was at a conference where the DOJ official says, I look not just at the response rate, but I really focus on the senior management response. So even if, for example, you have 95% completion rate, which NAVEX may benchmark and say, well, that's really good. The DOJ official will always say, well, who's in that 5%? If it turns out to be your CEO and your CFO, that may be a sign of bigger trouble, a sign of the tone of the top isn't right. Next slide, please. So, and this is the second observation from coming out of this research, is that employees are oftentimes very optimistic how they would respond to situations. And if you recall the interview experiment, sometimes real life doesn't reflect what you think that you would do. So when we think about what kind of compliance ideas are there, one thought you have is when you're conducting the risk assessments that Greg talked about, you do interviews, you do questionnaires, but instead of asking people, what do you think your biggest risks are? What do you think our company's biggest risks are? Ask them about the risks that they think their colleagues are facing or their competitors, because people have a tendency to think, well, I'm not worried about that because I know that I would never do that wrong. But they don't have quite as much faith in their competitors. And that's why if you ask about what they're thinking, you can oftentimes get more insight in what could potentially go wrong at your company. Another interesting observation is that if you have money or finance in your title, those folks should get a lot of training. It's interesting that they've been able to figure out that if you have these kind of finance related titles, there is a greater tendency by those folks, not that they're not good people, but there's a greater tendency for them to say everything was a business decision. I'm looking at the numbers. 10 is greater than 8, therefore 10 is the right decision. And as I noted, tough call, but this is more profitable. So do focus your training on the money employees. The other thing that I would mention is something called managing the gray. And managing the gray is this concept that for some issues, companies tend to tell their employees, look, this is kind of a tough area, kind of falls in the gray area, you should be really careful. And what they found is that whenever you kind of give vague instructions, people tend to run with that. If there's a pinhole exception, they will drive a truck through it. And this is particularly prevalent in certain countries and cultures. And really the thing to think about here is speaking up. If there are gray areas, encourage people to talk about the issues, to report the issues, and to get guidance. Continually stress that compliance is there to help you. And the buzzword now is establishing a speak up culture. But that will help get your company in a place where even if there's some vagueness, at least people are talking about it and getting clear answers. Otherwise, just say, hold tight until I come back with you with an actual answer, but suggesting, yeah, it could be tough. That's where people employees in particular, seem to take advantage. Next slide, please. So the other observation is that there is a very strong correlation between people engaging in misconduct and the amount of time that passes without someone correcting that, or there's being some sort of countervailing message that said, actually, this is wrong. So as simple as it sounds, the more compliance messaging that you're able to do, the better. And the best example that I can think of is you think about the safety context. Many factories always start off their morning with a safety inspection or a safety discussion, and that has been shown to dramatically increase safety because it keeps safety front of mind for all the employers and employees. And similarly, having those sort of compliance minutes, starting a call with saying, let's remind you about this issue, let's talk about third parties, let's talk about proper invoices. Those sorts of simple, easy messages oftentimes are very effective, and they can counteract any sort of unethical behavior you're seeing. Second, small issues can turn big quickly. Even if you have a tiny leak in a house, it's going to ultimately destroy the entire house if you don't deal with it properly. So it's really critical to make sure that managers are trained to understand the importance of very promptly correcting any sort of misconduct they see. And it doesn't necessarily always have to be penalties. It can be viewed as learning opportunities, trying to take something that is not being done perfectly and saying, let's do it this way. This is the right way to do it. This is how we do it. This is how our company does it. Can be very effective in getting folks to engage in the right conduct. Another one which I think is very important is just-in-time messaging, and that is employees, I think on average, tend to forget what they just learned in about 2 weeks. So in 2 weeks, you're going to forget about all of this. But if you send out compliance reminders before key events, that will help prompt them and keep the message front of mind. Sending out, for example, an antitrust reminder before a trade show starts, as they're trying to get approval for going, spending the money to get on a plane to go to a trade show. Talking about insider trading before transactions. Thinking about how you can get that just-in-time messaging. Next slide. So the last two things I just want to talk about is messaging and doing it the right way. Very quickly, because I see that there's only a few minutes. One, Jen Lane talked about this. If you can create top 10 lists of here are the things that are really, really important, that is the best way to get people thinking about it. No one can recite an entire policy, but they will remember a top 10 list. And if you focus on those sorts of things, that's helpful. Even if you have a great policy, create a top 10 list. Presenting ethical reminders at the outset instead of the end. If you start an interview, remind them that they need to be honest and truthful, and that's the most important thing. They had reports that if you say that up front, the accuracy goes up 12% by having that reminder at the outset instead of the end. COVID face-to-face interactions is more difficult, but not surprisingly, it's better to be face-to-face. And last slide. Last slide is how you message things can be really important. You think about how they message, the different ways to message safety. One way to do it in a traffic zone is to say, hey, we're in a construction zone. Your fines are gonna triple if you drive through here too fast. Another way to do it is to say, slow down, save a life. We're all in this together. It turns out that studies show that the second way is far more effective. So think about ways that you can reaffirm a positive trait instead of always threatening people, because people don't seem to respond well to threats. And finally, one of the best ways to understand how this happens is to train your employees on unconscious biases. Tell them what we just said, share the matrix studies, and that'll at least have people being mindful of the fact that there could be these issues that they're not fully thinking about. So I think that is the end of my time. If there are any questions from the audience, we can certainly take those and send them in. But otherwise, thank you very much, and I will pass it along back to Mike and Bobby.
Thank you, John.
And I think now we're ready for another CLE code.
At this time, I will announce the second CLE code. For those seeking CLE credit today, please type the 5-digit code into the Q&A box with your email and hit send. Again, it is imperative to send your credentials and the code to receive credit for today's program. If you need the attorney affirmation form, it is located in the survey link in the Q&A box. The second CLE code is ZNBWH. Again, that is Z as in zebra, N as in November, B as in boy, W as in whiskey, and H as in hotel. One more time, the second CLE code is ZNBWH. Thank you.
Right, thank you. And at this point, we'll take a 5-minute break.
All right, everyone, let's get started with our second round of presentations after the break. Welcome back. I want to reiterate a few housekeeping notes before we get started. For those of you that might have questions about any of today's topics, please, we invite you to type them into the Q&A box on the screen. If you prefer to have them answered and time does not allow, please make sure that you include your name and email address, and someone will follow up with you to answer the question after the webinar is over. If you're having any technical difficulties with the webinar platform, just refresh your browser and leave the meeting and join back in. Either of those may work. If for some reason that doesn't work and you continue to have issues, please email the folks at videoconferencing@foley.com and someone will get back to you. A reminder that a copy of the slides and materials, there are written materials as well as the slides that you are seeing on your screen today, will be sent out in our post-event communications. They will also be shared in the announcements under the featured tab in the Q&A box. And finally, our annual and regular reminder that feedback is so important. And so as a final note, a short survey link will be posted during the webinar and also emailed out to everybody who attends. And we'd really appreciate it if you'd provide us either feedback on our webinar to make sure we can improve any future presentations. All right, with that, I'm going to stop talking and turn you over to our next presenter, who is Pedro Fragoso Perez, who will be presenting on product distribution and franchising in Brazil. Pedro?
Thank you, Bobby. Hello, everyone. I am a Brazilian licensed attorney and a foreign legal consultant in the US. My topic today is going to be product distribution and franchising in Brazil. And I will start with a brief overview of our agenda. I should have added a slide for that. We're going to go over some definitions. Then we're going to go over the changes by the new Brazilian franchise law. We're going to talk about the Brazilian franchise disclosure document. And finally, we're going to talk about some registration issues. So to get started, next slide, please. So here are some definitions. And the reason why this is important is because in Brazil, people, they get very confused with the differences between agency, distribution, sales representation, and even franchising. Those concepts, they have some similarities, but they have differences. So we're going to go through the definitions in a way that we can understand exactly what each one means, right? In Brazil, as you may know, Brazil is a civil law country. So the Brazilian Civil Code defines agency, where one assumes on a habitual basis and with no subordination, the obligation of promoting on account of another upon a compensation certain businesses within a geographic area. The distribution is when the agent has possession of the goods to be traded. So that's the difference between the agency and the distribution. While in the agency, the agent only intermediates the orders. In the distribution, the distributor has possession of the goods. The franchise law, the Brazilian franchise law, actually the new Brazilian franchise law was enacted in December of last year, but it only came into force in March of 2020. So it's still a new law, and it brings a new language for the definition of franchise. So according to the law, the franchise is the system where the franchisor authorizes by means of a contract the franchisee to use trademarks and other intellectual property rights, always associated to production or exclusive or non-exclusive distribution rights of products or services and use of methods and implementation and management of a business or operational system developed or owned by the franchisor, upon direct or indirect compensation, without characterizing a consumer or employment relationship in relation to the franchisee or its employees, even during training period. So the very last part of this long definition is an improvement of the new law, because as a way to mitigate the employment risk, it expressly added language to the new law, stating that there is no consumer relationship, there is no employment relationship. It's a franchise, it's a commercial, it's a civil relationship. Next slide, please. Regarding termination, that's also important. A common concept for agency, distribution, and franchising, and even sales representation is the amount of investment that the agent, the distributor, the sales representative, or the franchisee made to this business. So the agency and distribution agreements, when they are entered for an indefinite term, they may be terminated at any time by any party upon a 90-day previous notice, as long as sufficient time has elapsed permitting the agent or distributor to recover required investments. So this is the key issue, how much investment they made into the agency relationship or the distribution relationship or the franchising relationship. And in the event of a dispute, the court is the one to decide as to the sufficient time, whether it's sufficient time or not, and the amounts due. The agreements entered for a definite term, they cannot be terminated without a cause, unless the agreements provide for termination. And even so, the termination of definite agreements without cause may subject the contracting party to honor the compensation due up to the date of termination, including paying the proposals, in addition to indemnification provided for by specific legislation. And what legislation is that? It's the law that governs the sales representatives, because we have the Brazilian Civil Code, we have specific legislation, I just mentioned, the sales representative law. We also have the franchise law, which is also specific legislation. They all walk together. They all walk together in their common principles. The termination of franchise agreements requires cause as well. And the franchisee may claim damages if verified that the franchisee made a lot of investments that he was not able to recover during the franchise relationship. So as I mentioned, we have a new law in Brazil. This law came into effect in March 26, 2020, and it replaced the former law, which dated 1994. This new law preserved several concepts of the former law, but it came to improve the franchise relationship, as I mentioned. So some of the concepts that it preserved were, for instance, the obligation to supply the prospective franchisee with the franchise disclosure document, what we call Circular de Oferta de Franquia, or COF. So if you ever hear about COF, or Circular de Oferta de Franquia, we are talking about the US franchise disclosure document. It's the same document. So there is a deadline for that, which is at least 10 days prior to the execution of the franchise agreement or payment of any fee by a franchisee. And the new law also imposed stricter disclosure obligations on franchisors. Next slide, please. Next one, please. Okay, so here is a summary of the most important changes of the new law. First, as I previously mentioned, the new law added specific language to avoid, to mitigate any employment, any consumer risk on the franchise relationship. Second, in a sublease agreement, the renewal of the main lease may be proposed by any party, either the franchisor or the franchisee. And in a sublease agreement, the franchisor can make a profit out of the sublease relationship. In other words, the franchisor can charge a higher rent from the franchisee than the franchisor pays to the landlord. As long as, and this is the important part of this, it's clearly stated in the franchise disclosure document, the Circular de Oferta de Franquia. And that's how this document is so important, and in the contract. And the rent plus, the profit made out of it, cannot affect the economic balance of the sublease in the franchise relationship. The new law also added penalties. It provides for penalties to franchisors who omit information required by law or include false information in the franchise disclosure document. And finally, I would like to mention the possibility of arbitrating a franchise dispute. So now the parties, they can elect arbitration as a mechanism of dispute resolution. And why is this so important? It's because before the new law, we didn't have that express in the formal law. So the Brazilian Superior Court of Justice ruled in different ways regarding this, because some of the judges, the justices, they held that the franchise agreement, because of the Circular de Oferta de Franquia, or the franchise disclosure document, it was like an adhesion contract. In being an adhesion contract, you could not force the franchisee to start arbitration, or to go to arbitration. Now this issue has been resolved. It's not disputed anymore with the new law. It's expressed in the language that the parties, they can elect arbitration. Next slide, please. The new law also provides for the authorization. Now, when we discussed the definition, when we saw the definition of franchise according to the law, part of it stated about the authorization to use trademarks and other intellectual property rights. So the condition for that is that the franchisor must be the owner or applicant of the trademark and other intellectual property rights negotiated in the franchising agreement. So not necessarily the trademark has to be finally granted in order for the franchisor to be able to license the use of the trademark. That's why the word applicant is here, not only owner, okay? The only condition for that is that that has to be cleared in the franchise disclosure document. And the second scenario is it has to be expressly authorized by the owner. And the franchise may be adopted not only by private entities, but also by state-owned companies and non-profit organizations, regardless of their activities. Next slide, please. Well, here, this is the black letter of the law. So I'm going to have to go through it because, as I mentioned, a great part of the new law is regarding the sophistication of the franchise disclosure document, the information that must be there in order to have full disclosure. So the franchise disclosure document, or the Circular de Oferta de Franquia, must be in Portuguese and contain the following information: a summarized history of the franchise, full information about the franchisor and its related entities, balance sheets and financial statements of the franchisor relating to the 2 previous fiscal years, list of court cases relating to the franchise that challenge the system or that may prejudice the operation of the franchise in Brazil, in which the franchisor, its controlling entities, the sub-franchisor, and the holders of the trademarks and other related intellectual property rights are a party. A detailed description of the franchise and a general description of the business and the activities that will be performed by the franchisee. A profile of the ideal franchisee as it relates to prior experience, level of education, and other characteristics that the franchisee must have or may preferably have. The requirements as to the franchisee's direct involvement in the operation and management of the franchise. Specifications about the total estimated initial investment. Implementation, next slide, please. And start of operations of the franchise. Initial joining and franchise fees, we are in letter B. Now let us see the estimated value of the facilities, equipment, and initial stock, as well as payment terms. Information about regular fees and other fees to be paid by the franchisee to the franchisor or third parties appointed by the franchisor, detailing the corresponding basis of calculation, what they compensate, or its purposes, indicating specifically the following: regular compensation for the use of the system, trademarks, and other IP rights owned or held by the franchisor, or services handled by the franchisor to the franchisee. Publicity fee, equipment or commercial facility rents, minimum insurance. Next slide, please. Complete information on all franchisees, sub-franchisees, or sub-franchisors, and all those who have ceased the franchise relationship in the previous 24 months with name, address, and telephone number. Information on territorial policy, including whether the franchisee has exclusivity or a right of first refusal over certain territory and under what terms, whether the franchisee may sell its products or handle services outside this territory or export, whether there are and what they are rules for territorial competition between franchisor and franchisees, clear and detailed information on franchisees' obligation to purchase any goods, services, or raw materials required for the implementation, operation, or management of the franchise from franchisor-approved suppliers, including complete list of these suppliers. Next slide, please. Indication as to what will be offered to the franchisee and in what terms related to support, network supervision, services, technological innovation, franchisee and franchisees, employees training, including duration, content, and costs, franchise manuals, assistance in the analysis and choice of location where the franchise will be located, and layout architecture, specifications of franchisees' facilities, including drawings of equipment, descriptive memorandum, and composition. Complete information on trademark and next slide, please. Complete information on the trademark and other intellectual property rights related to the franchise. Franchisee situation after the expiration of the contract in relation to know-how of product technology, process of management, confidential information related to industry, commerce, finance, and business to which the franchisee has had access as a result of the franchise. Implementation of competitive activity. A full copy of the standard franchise agreement to be entered into with the potential franchisee. Indication of assignment or succession possibility and what are the rules. Events that will trigger penalties, fines, or damages in the corresponding amount. Information on the, next slide, please. Information on the existence of minimum quotas purchased by the franchisee from the franchisor or third parties. Indication of existence of board or associations of franchisees. Indication of the rules limiting competition between the franchisor and the franchisee. Precise indication of the franchise contract's terms and renewal conditions. Location, date, and time for receipt of the proposed paperwork, as well as opening of the envelopes in case of public entity. Next slide, please. So I'm sorry to go fast over this, but I think it's important to understand what information is required in the franchise disclosure document. As you see, the franchise disclosure document, the Brazilian franchise disclosure document is a very sophisticated document, and disclosure is key for the drafting of such a document. So in the event of a public bid, the franchise disclosure document must be disclosed at the beginning of the selection process. if there is no compliance with that, so in case of non-compliance with this provision, a bidder may claim it's new or void, and the bidder can demand refund of any fees paid to the franchisor or those appointed by the franchisor as filiation or royalties monetarily adjusted. The franchisor who omits, we mentioned this before, the franchisor who omits information required by law or discloses false information in the franchise disclosure document is subject to the same penalty indicated above, as well as criminal sanctions. So all provisions governing the franchisor and the franchisee also govern the sub-franchise relationship. The franchisee agreements must meet the following requirements. Those to produce effects only in Brazil must be drafted in Portuguese and governed by Brazilian law. Next slide, please. The international franchise agreements must be originally drafted in Portuguese or certified to Portuguese. The certification costs must be borne by the franchisor, and the contracting parties may opt in the agreement for the form of one of their domicile countries. So the party may elect arbitration as a mechanism to dispute resolution, as we mentioned before. Here, where you can find the definition of international franchise agreement, which means those that by the acts of concerning its enforceability, the parties nationally or domicile or its purpose have liaisons with more than one legal system. In the event the foreign is provided international franchise agreement, the parties must appoint and keep a qualified legal representative or attorney at law domicile in the country. The new law must be applied jointly with the existing Brazilian intellectual property laws. So this is the final slide. I think we are right on time, but this is important to mention the registration. The registration of a franchise agreement is necessary when the franchisor is domiciled outside Brazil. So registration of an international franchise agreement is a condition for the deduction of royalties. So for tax purposes, the contract must be registered. And in relation to the trademarks licenses as well. And if you want to remit funds, royalties abroad, that's also why it needs to be registered. And the registration is done with the National Institute of Industrial Property, not intellectual property, industrial property, which includes intellectual property, and the Brazilian Central Bank. So the Brazilian Central Bank is just to allow the party to remit royalties outside Brazil. So that's it. And with that, I turn it over to Bobby and Mike. Thank you very much.
Thank you, Pedro. I see we have no questions from the audience for you at this time. So with that, we'll move on, and I'd like to introduce Marcos Carrasco from our Mexico City office, who will be presenting an overview of product distribution and franchising in Mexico. Marcos, thank you.
Thank you, Mike. Good afternoon. As Mike mentioned, I'm a partner in the Mexico City office. My practice area is international trade and customs. So in the next 20 minutes, I will explore with you the different figures that a company may use to distribute products in Mexico, but with a different approach. I will not discuss those figures from a contractual standpoint, but from a Mexican customs perspective. I will navigate on the general implications for introducing products into Mexico from this customs perspective, to then move to a couple of alternatives that you might consider to distribute your products in Mexico. Next slide, please. So which are the common suspects that companies usually use to distribute products in Mexico? I would say that supply, distribution, sales through agents and sales representatives, and perhaps using a branch or incorporating a subsidiary in Mexico. Next, please. So let's start with supply agreements. I will refer here to the customs and tax implications upon sales through these supply arrangements. And first, as per delivery, even though Incoterms will usually rule the terms and conditions of the operations, in our experience, the supplier usually delivers its products before customs clearance in Mexico. In this kind of operations, the buyer usually acts as the importer of record, and as well, these operations will usually involve definitive imports into Mexico. So as an important consideration, it is worth mentioning that to import into Mexico, an importer's license is required, for which registration as a taxpayer is as well needed. Next slide, please. So although it will depend on the specific commercial arrangement, in supply agreements, the buyer usually is the one that pays importation duties, importation VAT or value-added tax, customs processing fees, customs brokers fees, and when applicable, anti-dumping quotas or anti-dumping fees. In addition, an importer will have to demonstrate compliance with non-tariff regulations upon the importation of the products. And by non-tariff regulations, I mean labeling requirements, sanitary permits, safety regulations, consumer protection regulations, among others. So another thing you should take into consideration is that once products are imported, sales will be performed by the buyer since he's the owner of the imported products. And as you all know, sales in Mexico trigger value-added tax, which is which is actually shifted to consumers at a 16% rate. Buyer, for sure, will assume all the tax burden of all the sales in Mexico. Next slide, please. As per the distribution figure, I'm talking about the place of delivery and the rest of the implications. These are very similar to those that I have mentioned for supply agreements. We have seen that in distribution agreements, parties usually agree to deliver before customs clearance in Mexico. The distributor will usually act as the importer of record. He will carry out the importation through definitive importation regime. And as previously mentioned for supply agreements, the importer will require to have an importer's license, and for that to be incorporated as a taxpayer. Next slide, please. Moreover, and with the intention for you to learn them by heart, such as it happens in supply, the distributor as the importer of record will usually have to pay importation duties and importation taxes, fees, and anti-dumping quotas if applicable. In addition, the distributor will have to demonstrate compliance with non-tariff regulations, which I already referred to them before. Next, please. And we'll have the tax burden of the sales into Mexico. And such as in supply, sales will trigger value-added tax, which will be at the end shifted to the consumer. As a particular situation to consider, in the case of distribution agreements, the seller should be very careful to verify if the distribution operation does not constitute a permanent establishment for income tax purposes in Mexico. So that should be definitively analyzed if intending to implement a distribution chain in Mexico. Next, please. So now jumping to sales through agents and sales representatives. And to avoid unnecessary repetitions, I will only say that once the sale is concluded in the name of a foreign resident seller by its agent or its sales representative, the implications will be the same as in the distribution. So in this case as well, seller should be aware of verifying if the activities of the agent or sales representative will cause a permanent establishment in Mexico for income tax purposes. Next, please. If thinking about distributing directly, there are two traditional ways to do it, either through a branch registered as a taxpayer in Mexico, or by incorporating a subsidiary to be as well registered as a taxpayer. Please remember that being registered as a taxpayer is a requirement to obtain an importer's license, as we mentioned before. So in this case, the Mexican branch or subsidiary will act as importer of record and ultimately may sell the products in Mexico. Next, please. As importers, the Mexican branch or the subsidiary will have to pay importation fees and taxes as well to comply with any non-tariff regulations. I will not refer to them specifically. We already referred them before. Moreover, in this case, the Mexican branch or subsidiary as the sellers will have to assume all the tax burden upon the sales conducted in Mexico. Lastly, there is the issue of the value-added tax to consider. Sales, as we were mentioning before, within Mexico trigger the VAT, which is shifted to consumers at the 16% rate. Next slide, please. So as common implications and as a conclusion, which are the common implications to the distribution figures that I wanted you to consider? First, the importer is required to be registered as a taxpayer and as a licensed importer in Mexico. Then, except for operations through a branch or subsidiary, sales are concluded outside of Mexico, despite of the agreed Incoterms and place of delivery. Since the products will be resold in Mexico to Mexican consumers, importations are usually performed under definitive importation regime. Importers, in all the cases in Mexico, will be liable for the customs clearance of the products, payment of any applicable duties, fees, and taxes, and of course, compliance with non-tariff regulations. Importers in Mexico will have the tax burden resulting for the result in Mexico, and I did not include it here, but just to remember, 16% VAT rate is shifted to consumers upon the sale in Mexico. Next, please. So I was referring when I started to two alternatives that you may consider to distribute in Mexico. And these customs alternatives are importation through a bonded warehouse and temporary imports through a services IMEX company. I will refer after to the IMEX acronym. Next slide, please. So speaking about importation to a bonded warehouse. This opportunity implies introduction of products to a general bonded warehouse, which is an in-bond facility authorized by the Mexican Treasury to store foreign and national goods for purposes of further importation into Mexico or exportation, or if introducing products into the bonded warehouse to return them abroad. The bonded warehouse regime is a customs regime, such like the definitive imports, the temporary imports, the transit. Through this regime, goods, either foreign goods or national, this is Mexican goods, may be introduced to a general bonded warehouse. As a highlight of this regime, you should know that foreign residents, such as US residents, are entitled to introduce goods into Mexico through the bonded warehouse regime. This will be the only regime that authorizes foreign residents to introduce goods into Mexico. If it is not through this regime, it is necessary, as I explained before, to be incorporated as a taxpayer and to have an importer's license, which are not required if a foreign resident introduces the goods through the bonded warehouse regime. To introduce the goods, the issuance of a storing services letter by the general bonded warehouse authorized holder is required. So foreign residents may introduce goods into the warehouse, but they cannot extract them for importation into Mexico, only for exportation purposes. And I will further explain this. So goods may be kept in the bonded warehouse in the regime up to 24 months. Goods kept at an in-bond facility by foreign residents may be sold to Mexican or foreign residents, either for exportation or importation purposes by the buyer. So those acquiring the goods kept in the in-bond premises would be responsible for complying then with any obligation pertaining to the regime or pertaining to the importation. For instance, if the buyer of an in-bond good decides to extract it from the in-bond facility for importation purposes, it will be obligated to carry out the payment of duties, fees, and taxes, and any quotas, if applicable, such as the ones that we were mentioning before, when we talk about supply and distribution in Mexico. So foreign resident sellers must consider that the Mexican tax authorities have ruled that sales of inbound goods trigger sales VAT in Mexico. They consider the sales as conducted in Mexican territory, even though the product is not imported under a definitive basis yet. So if a foreign resident without a permanent establishment in Mexico sells inbound goods, the value-added tax must be calculated upon the sale and charged to the buyer. In such a case, since the foreign resident will not have a permanent establishment in Mexico, then the buyer will be obligated to withhold the tax from the foreign resident seller and to pay the corresponding value-added tax to the Mexican Treasury. That's an important implication. We have been involved in numerous cases in which buyers in Mexico of products that are kept in inbound facilities do not withhold this tax, and they are ultimately assessed by the Mexican Treasury and assessed with omitted duties and omitted fines. So this is worth noting if you once will try to sell products through this bonded warehouse regime. I believe that the regime is an option for foreign resident suppliers that are required to maintain a certain stock of goods, but do not want to enter into an agreement with a third party in Mexico for that purpose, neither to have a presence through a branch or a subsidiary. As in the case of distribution or sales by sales representatives, this figure will require a verification of if the operation will constitute a permanent establishment for the seller in Mexico. Next, please. So I will now speak about the temporary imports through a services IMEX. IMEX, if you are not familiar with the term, is the acronym for the Manufacturing, Maquiladora, and Export Services Industry Program, which is authorized by the Mexican government to qualifying Mexican entities. On your materials that were shared, you will find a couple of notes that we published with a more detailed explanation about the IMEX program. But a large number of U.S. manufacturing companies operate facilities in Mexico through this program, so that's why I consider it was important and worth to explain this option. So the IMEX program allows qualifying companies to import goods into Mexico under a temporary basis to be used in the manufacture of final products that are meant to be exported from Mexico or to render export-related services. Goods like raw materials are free of importation duties if imported through this IMEX authorization. It is worth noting that the sale of products imported by an IMEX company to be transferred to another IMEX company may be exempted from value-added tax, or sales will trigger only VAT at a 0% rate rather than the general 16% rate. As mentioned above, the IMEX program may be granted either for producing exportation final products, which this will fall into the category of industrial IMEX, or for rendering exportation services. In this case, the program will be called Services IMEX. So within the Services IMEX, there's a feature of warehousing and distribution activities that may be authorized as exportation services under the IMEX program. So if a U.S. supplier has clients in Mexico that require the delivery of products to IMEX facilities established in Mexico, it may analyze the alternative of establishing an IMEX facility for warehousing and distribution purposes. Such alternative will allow the supplier to import products into Mexico without paying importation duties, to be further sold and delivered to an IMEX facility, and without paying sales VAT in Mexico, which is relevant. And I mean, to validate this alternative for a company, an analysis on a case-by-case basis should be performed. Establishing an IMEX company in Mexico is not an easy task. the strict rules to be complied and to obtain Animex companies are established by the Mexican government. Because of abuses of this program in the last 5 or more years that have been committed by a large number of companies, the Mexican government now is somehow reluctant to grant the programs, but it is not impossible. So you should consider this alternative as a feasible alternative to distribute products to companies in Mexico that have IMEX authorizations to produce exportation products. So this is the end of my presentation. If you have any questions, I'll be happy to provide an answer. And I go back to Mike and Bobby. Thank you very much.
Thank you, Marcos. Our next presenter is going to be Marco Najera, who's also from our Mexico City office. And he will be talking with us this afternoon about pricing exclusivity and antitrust issues in Mexico. Thank you, Marco.
Thank you, Bobby. Hello, everyone. I'm Marco Najera. I'm a partner in the Mexico City office, as Bobby just mentioned. My background is I am a transactional lawyer that combines its time also with regulatory and antitrust work. So the idea, after having Marcos talking about customs, foreign trade, and other topics like taxes, I will give a quick overview of key concepts that will apply still in Mexico from a transactional, general legal perspective, regulatory perspective. So for you also to have that part, which is very important while doing business in Mexico. But my emphasis at the end will be antitrust, how issues like pricing, exclusivity, non-compete clauses can be dealt in Mexican territory due to the application of our antitrust laws. So if we can start with the slides, I will appreciate it. Okay. So on the general part, labor is a very important issue to deal in Mexico. Many cases and errors by companies are not properly structuring the labor relationships in the country. This is because labor law in Mexico is very, very protective for employees in Mexico. Labor laws provides, for instance, a number of benefits for the employee that should be paid and that are obviously cumbersome. This includes, for instance, Social Security, profit sharing, and most importantly, termination rights for the employee, which would involve eventually the right for the employee to obtain a severance payment by the employer. So it is very important when you have a distributor or a franchise or a franchisee in Mexico to stop and think about the potential labor risks in Mexico. There is, because Mexican laws are very protective and formalistic, there is always a gray area between a distributor and an employee that you need to think about. And you need to structure this correctly from the beginning. One of the key issues or tips that I can give you is to try to use always corporations as your distributors, company distributors, as opposed to one single guy or individuals being your distributor. Companies are not employees from the beginning, so individuals are always in a very gray zone area, especially if you are they are your representatives, etc. So try to avoid individuals as distributors is the one key factor. Secondly, if you use a company distributor, try to set up very clear rules that imply that this is going to be a commercial relationship out of a labor relationship, and try to do that with the proper wording in the agreement, but also in the facts. You can put in the agreement many things and within the contract, but if at the end of the day you treat your distributor or the employees of your distributor as your own employees by, subordination or providing certain instructions, work time, specific places to be, etc., that can lead you to a labor relationship. So be careful on that. That is one of the key issues while doing business in Mexico. The next one, please. Also linked to the labor risks, be careful with the termination clauses and the term of your agreement. Try essentially, and if possible, to use fixed terms, not subject necessarily to renewal. That will give you the perfect escape clause without the needing to terminate the agreement and to notify the termination due to these labor issues that I mentioned. Because if you notify a termination, you will have always a risk or a potential risk for severance to the distributor, which should not apply in a commercial relationship. But again, try to structure this properly from a labor perspective and a termination perspective. If the fixed term is not possible, then think on clauses of early termination rights without a cause, just simply because one of the parties is willing to terminate with a prior notice term, which is reasonable, 3 to 6 months, and doing that in writing. Be careful on how you notify the termination to the other party, to the distributor, to the franchisee. Mexico is very formalistic. Sometimes emails, although they are accepted, will not be sufficient proof in case of dispute. Try to use notaries, for instance, in Mexico, or corredores públicos, which is another alternative, which is relatively close to a notary. They will charge fees, but they are, it's a good option to notify termination issues. And if there is a termination due to just cause that it's been negotiated, we try to be very clear in the definition of the concepts so that you do not lose opportunities of terminating the agreement due to that drafting errors. The next one, please. Now, another very important risk while doing business in Mexico, as in other countries in Latin America or Asia, China, etc., is corruption. Although Mexico has been moving towards a more effective anti-corruption law and regimes, and there are important efforts by our country and our president today to enforce anti-corruption sanctions, you need to bear in mind two very important factors. First of all, US FCPA and other foreign laws that have an extraterritorial effect, like in France or in the UK, will be also applicable to your depending on where your parent company is located, to the relationship that you are going to build in Mexico. So be always very careful on anti-corruption clauses, strong clauses in your agreements. Impose not to do obligations and controls to your distributor or to your franchisee, especially if they are going to be doing business with the Mexican government through public bids, etc., or if the distributor or the franchisee will need to obtain certain licenses or government, or will we have any connection with government procedures. So be very careful on that. Try to make your distributor or franchisee to agree upon your policies, your corporate policies, and also for them to impose to their own employees anti-corruption, strong anti-corruption and ethical rules, which you can be able to supervise from time to time. If we can move on to the next one, please. Also, it is important to check what will be the main regulatory and compliance issue to deal with in Mexico. Certain products in order to be sold in Mexico will require licenses, like for instance in food or pharmaceutical products. You will need to comply with certain official standard or norms called NOMs in Mexico for product safety, etc. Also, while selling your products in Mexico, the warranties The product warranty will need to have certain language and specifications, so be careful on consumer protection rights as well. If we can move to the next one, please. This is, there is not when dealing with law and jurisdiction, you need to check this case on a case-by-case basis. Although in Mexico, you can subject your agreement to foreign law, you need to always think twice on choosing that as your governing law or jurisdiction for your contract. This is obviously you can think in an arbitration clause, always depending on the value and the technical issues that may be involved in case of a dispute. But bear in mind that enforcing a foreign judgment or an arbitration award in Mexico needs still to go through Mexican courts. So you will probably need to do 2 different procedures because Mexico requires a constitutional review process called homologation. The next one, please. Well, and you need to also register your trademarks properly, and you can think on trademark license agreements to be registered with the IP authority in Mexico. So that is another issue that is always recommended to deal with in our country. So we can move on to the next one, and obviously you need to take care of the tax and customs issues that Marco discussed. But the second portion of my time, I will try to go deeply as possible with some 10 minutes or so on discussing the key antitrust issues to observe in Mexico. First of all, antitrust law in Mexico is mandatory at all federal territory in Mexico. This means that we will not have antitrust laws on a state-by-state basis, but that we have one single antitrust law. Antitrust enforcement and fines is something that is very, very serious in Mexico. So this is a very key, as it is the trend in many countries in the world. We heard the case of Brazil, etc. So this is a very important issue also to address in your distribution or franchise relationships. Now, what are the typical issues that you would need to deal with or to review from an antitrust perspective in Mexico? Well, it is natural that the relationship with your distributor or with your franchisee would be a vertical relationship, a supplier-distributor relationship. Okay, so in Mexico, an antitrust or illegal practice is abuse of dominance, or which is also called in Mexico relative monopolistic practice, according to our law. For it to occur, different factors need to exist, and not necessarily a conduct that could be regarded as an unlawful or an anti-competitive conduct would fall into that particular scenario. But we need to always think that for an abuse of dominance to exist, one of the parties should be dominant in the Mexican market, either the supply in the Mexican market, or there could be also different definitions of the geographical relevant market. It's important to check if it is also dominant at NAFTA region or perhaps from a worldwide perspective. And to check these both from the supplier and distributor perspective. There are certain distributors that would be trying to sell your products. We have seen many cases in Mexico that they are already a strong competitor in Mexico, and they could be dominant per se. So try to check that as well. And also try to think if by any reason you would be competing as well with a distributor in Mexico. Or if you are going to use not only one distributor, but someone else would be selling your products in Mexico, because in that case, you will need to check also if there could be any implications at horizontal level, meaning if there could be any absolute monopolistic practice or collusion between potential competitors or competitors in Mexico. If we can move to the next one, please. Now, the typical clauses or provisions that you are willing to probably address in a distribution or franchise contract are exclusivity, non-compete, and pricing conditions. So depending on the situation where you are, as I have already explained, these type of provisions could be or may not be illegal in Mexico. Again, try to think if you are going to, if you as a supplier are going to compete or not with the distributor, and in order to check whether from a horizontal level there could be an antitrust issue in Mexico, and from a vertical level, if dominance may exist or if you can incur in an abuse of dominance practice in Mexico. The next one, please. Now, when exclusivity, non-compete, or pricing conditions could be illegal, again, from a vertical perspective, from a supplier-distributor relationship, when abuse of dominance exists, that is one of the key tests to check. Secondly, if the objective or effect of the transaction is to unlawfully displace other competitors from the market. And if those conditions exist, then probably conduct that is anti-competitive, like imposing exclusivity or non-compete obligation or imposing prices, that in that particular scenario, the abuse of dominance or the illegal antitrust practice may exist. Okay. Now, from a horizontal perspective, this is if you are going as a distributor to compete, as a supplier to compete with a distributor, or if there will be different distributors or players competing among each other selling your products, you will need to think that any type of provision, including exclusivity, non-compete, or fixing prices or imposing pricing conditions, should be normally illegal per se, and not depending on whether any of the parties is dominant or has a substantial power in the Mexican market. If we can move to the next one, please. Now, from a non-compete provision perspective, again, I mean, many transactions, for instance, in M&As, etc., and also included in distribution relationships, you want to have your distributor or the seller not to compete with your products or your services for a certain period of time. When, and how these provisions could be legal and enforceable and binding to the parties. First of all, when the non-compete provisions or obligations are not entered into between competitors. As we have said, all non-compete provisions or certain obligations not to do between competitors could potentially lead to an absolute monopolistic practice or collusion, like we have already explained, or in the case in a vertical relationship where one of the parties may have dominance in the relevant market in Mexico. Now, also other issues to address when you're dealing with a non-compete provision is to have an economic justification or certain consideration to justify the non-compete provision. Certain non-compete clauses, specifically when they are related to individuals, could infringe or not your labor right or your ability to carry out commerce, which is a constitutional right. So obviously there should be the right justification to try to impose this. There should be a territory and time limitation. Normally, trying to set up at the territory of Mexico and 1 to 3 years could be acceptable. And the non-compete obligation would be in selling the same type of products or services in which the supplier activity is related to. If we can move on to the next slide, please. When pricing conditions could be illegal, as we have said, basically at a horizontal level, when between competitors agree to fix prices or exchanging information with the purpose or effect to fix prices. For instance, you need to also be vigilant that your distributor, if it is a party of a chamber of an association of commerce, that they do not necessarily follow the recommendations for fixing prices or exchanging information of prices that are provided by those type of associations or chambers. From a vertical perspective, from supplier and distributor relationship perspective, it is illegal if, as we have explained, if dominance exists, to impose pricing conditions, to establish discounts or incentives that are conditioned not to sell or offer certain products of competitors. Also, imposing, selling below costs, to artificially increase costs or prices, etc. And you need to be careful also with between competitors or in certain issues when you deal with maximum or minimum prices. Setting up maximum or minimum prices are not allowed between competitors, but you can have certain flexibility in a vertical relationship, provided that you are not artificially inflating prices or artificially imposing the obligation to sell below cost or not getting the distributor certain margins in Mexico. So that is the end of my presentation, I guess, and I will open and I will check if there is any question or from the audience, or if we can turn back the microphone to Mike and Bobby.
Marco, thank you so much. So far, we have no questions from the audience, but again, they can still be submitted via the Q&A feature. Last but not least, we're happy to have as our final presenter today, Jamie Gekas, who is a partner in the Chicago office in the IP litigation practice, among others. And she's truly an expert in trademarks and other forms of IP, and will be presenting on the subject of brand management and trademark protection.
Hello, thank you. Last but not least, and also not to exceed the allotted time, so I will power through today. I know everyone is probably ready to get on to other things, but we've got some a jam-packed presentation here. Some of it will be fun. Hopefully everybody will learn something. Moving on to the first slide. We're going to focus on U.S. law today. If you were able to join the presentation last week from my partner, Laura Ganoza, she focused on trademark issues arising in Latin America. So today we are shifting the focus just for this module to U.S. law. To establish enforceable rights under U.S. law, you have to have use of your trademark in commerce. You do not have to have registration. So from the moment you start using a trademark in commerce on any goods and services, you're building goodwill and you are building trademark rights even if you don't have a registration. That said, a registration is super helpful, especially in today's world as we move more and more into a world where online, internet, social media is becoming extremely important. Having the trademark registrations in place is so helpful for enforcement purposes. More and more we are seeing clients who are not, rushing to send a demand letter. Often when there's an online infringement, we don't even know where the recipient may be physically located. We may not have an address where we can send a demand letter. So we may be trying to work through internet and social media platform providers to, have them accept a takedown, and a trademark registration is really the best way to accomplish that, to make that happen and to make it happen quickly and efficiently. How do you get a trademark registration? Well, you have to apply, but you also have to prove that you have priority. Priority refers to who is the earliest, the prior or senior user of a mark. The senior user, the first one to use a mark in commerce for specific goods or services, is the one who gets the best rights and can sue later users or junior users for infringement or engage in other types of lower level enforcement, such as sending a takedown letter. You can't establish priority without use in commerce. The mark has to be used publicly as a source of origin for goods or services. So if you have an internal promotion or campaign going on, something related just to your employees, even if you come up with a cool slogan or trademark type term, it's not going to be eligible for protection under US law until you take that external. You also can't establish trademark rights based on token use. So if you just sell a few widgets here or there to reserve rights, that is not going to cut it under federal law. You have to make actual legitimate sales in order to establish your trademark rights. Slide, please. The touchstone for trademark infringement, and also relevant at the trademark office when you're in the prosecution process, is likelihood of confusion. This is how you prove that there's been trademark infringement, by establishing likelihood of confusion. Similarly, when you're applying for your trademark at the trademark office, they will review prior filed marks, and if there is one that is too similar to yours for similar goods or services, they may issue a citation finding a likelihood of confusion with that earlier mark. So it's relevant in both places. In general, it's a complicated multi-factor test to determine whether or not there is a likelihood of confusion. Different federal courts of appeal have different ways of articulating it. The Trademark Trial and Appeal Board, which is the administrative review board for trademark office filings, has its own test. But in general, even though they may articulate it differently, all the federal courts and the Trademark Trial and Appeal Board are going to consider the same relevant information, the same type of factors. Here on the slide, we have a listing of the factors that are considered by the Seventh Circuit. They might, again, differ a little bit in how they are explained by various courts, but they're all going to be something along these lines. Obviously, similarity between the marks is the most important, but also, are the products or services offered under the mark similar? Where are the marks used? How careful are the purchasers? How strong is the plaintiff's mark? Is there any actual confusion in the marketplace? And did the defendant adopt the mark innocently or with an intent to pass off or to create confusion with the plaintiff's or senior user's mark? Slide, please. Often in a likelihood of confusion analysis, one of the first questions we get is how much confusion is necessary to prevail. You would be surprised it's not that high. If you commission a survey as a plaintiff and you can show that even 15% of your potential purchasing public or customers are likely to be confused by the junior user's mark, that's generally enough to establish a likelihood of confusion. If you have 50% or more, that is strong evidence. Also relevant to the likelihood of confusion analysis is where the products and services are offered and sold. If you have a federal registration, it gives you nationwide priority, but your registration is always going to be subject to the prior rights of an innocent prior user who may have been operating in a specific location. What that means is you could open 10 locations in 10 states, and all of a sudden, after many years of use, you could go into a new state, whether directly or through a franchisee, and there could be a local user there who pops up and has something to say about that. You may be in a position where you have to change your mark in that new location, where you have to work something out with the prior user who's located there. Often that can be expensive, so it's something to think about. Slide, please. Moving on from infringement, I want to talk a little bit about dilution, which is the other big trademark cause of action that you can bring if you have federal trademark rights. Infringement turns on, as we just discussed, the likelihood of confusion. Dilution turns on whether there is a likelihood that your mark's distinctive association with you and your brand is going to be diluted or diminished by someone else using a similar mark, potentially for a different product. There are two types of dilution. The first is blurring, which means use of your mark or a similar mark by someone else weakens that function to completely identify you as the source. An example is if you are selling Acme widgets for a long time in the marketplace and someone comes along and starts selling Acme cafeteria services, obviously, you know, your widgets are different than the cafeteria services. They're not in any way related. But from then on, when people say the word Acme, the first question is going to be, well, are you talking about the widget maker or the cafeteria company? That is, you know, just a hypothetical example, but it shows that's dilution by blurring. The other type of dilution is tarnishment. This is use of your mark in a way that casts it in a bad light. Usually in the past, tarnishment has come up when a mark is being used, a similar mark by someone in the adult film industry, for some sort of criminal endeavor, something involving drugs, something that most brands would prefer not to be associated with. Recently, we've seen a lot of activity around tarnishment claims related to the cannabis industry. Obviously, the cannabis industry is in high growth mode. It's kind of exploding. There's new businesses popping up every day. The law is changing. It's a complicated regulatory environment. A lot of more traditional brands don't really want to be associated with the cannabis industry if they're not operating in that industry. So we've seen a lot of cases around new cannabis brands trying to get trademarks through on various CBD products or medicinal marijuana products or dispensaries, what have you, that might be similar to established brands, and the established brands are not really thrilled about that. Important thing to remember for any dilution claim is that niche or regional fame does not count. So if you are famous in a specific niche industry or in a specific location, it's not sufficient. You have to have national fame. Think Coca-Cola, McDonald's, Allstate, American Airlines, those type of brands that are really readily recognized by the average consumer. Slide, please. This is just a sample case from a few years back that involves dilution by blurring. Black Bear Micro Roasters was a New Hampshire outfit. They had one retail location. They sold locally in supermarkets. They offered a coffee blend called Charbucks. Starbucks was not amused by that. They sued them for dilution by blurring. The case went on, it seemed like forever. There was a bench trial in 2005. Starbucks appealed to the Second Circuit no less than 3 times, no fewer than 3 times, and ultimately Starbucks failed to show a likelihood of dilution. Their mark was famous enough to qualify for dilution protection, but they were not able to meet the statutory test. And I think, this case is really interesting because it shows how tough it can be to bring a dilution claim. Slide, please. A case where the plaintiff did succeed on dilution by tarnishment is a case involving Dairy Queen. Dairy Queen is obviously a long-standing, pretty well-known mark. It was sufficiently famous to qualify for dilution protection. American Dairy Queen Corp. Sued New Line Productions, Inc. because they were going to come out with a new movie, a mockumentary-style movie that was going to be called Dairy Queens. It was satirizing beauty contests in rural Minnesota. This case is a little bit older, but it is one of the cases that's well known because the plaintiff was successful. The movie ultimately came out as Drop Dead Gorgeous, which is somewhat of a cult hit now at this point, 20 years on. You may have heard of the movie Drop Dead Gorgeous. It initially was supposed to be called Dairy Queens, and that change was because American Dairy Queen Corp. Sued successfully and got an injunction. Slide, please. Nominative fair use is another interesting concept in trademark law. This is also known as referential use. This is when someone uses your trademark because they need to identify you. I would say we get contacted at least once a week with a client who is upset that someone, usually on the internet or in social media, is using their trademark and they didn't give authorization. And oftentimes, unfortunately, there's not much we can do about it if the other user fits into the nominative fair use test. In general, the test is articulated as follows. Can the product or service be readily identified without using the trademark? If not, if the trademark is necessary, that tends to point towards fair use. Is the defendant using the mark more than is reasonably necessary? If the mark is being used once just to identify the trademark or the brand, that usually is sufficient. If it's being used gratuitously, that might tend to seem less like fair use. Has the defendant done anything to falsely suggest sponsorship or endorsement by the trademark holder? If the user of your trademark is making it seem as though you might have approved the use, that does not look like a fair use. If they're not doing anything to suggest that affiliation, it tends to weigh more in favor of fair use. Slide, please. There's a few fair use cases discussed in the materials, but I wanted to highlight just a couple of them here that I thought were interesting. The first one is, excuse me, it relates to a book that was placed on Kickstarter. It was going to be called "Oh, the Places You'll Boldly Go." It was a Star Trek themed book, but also a parody of the Dr. Seuss book, "Oh, the Places You'll Go." And Dr. Seuss Enterprises was not amused, sued for infringement. The court, the Southern District of California in 2017, found in favor of Dr. Seuss. They found it was unnecessary to borrow not only the title, but also the font, the punctuation to actually make it look like a Dr. Seuss style book. All of that weighed against a finding of nominative fair use, and the defendant there lost. On the other side, we see a social media snap from Noom, which is a app-based weight loss company startup. Done a lot of advertising over the last 2 years, particularly on Facebook. And a lot of their advertising targets the famous long-standing Weight Watchers brand. Noom tries to paint Weight Watchers as being outdated, out of touch, uncool for older people. And many of their ad slogans relate to that sort of concept. So here we see the program that millennials are calling Weight Watchers 2.0. Weight Watchers sued in the Southern District of New York in 2019 and said, you know, have your app-based weight loss company, but you don't need to keep name checking us. That's gratuitous. There's no way to do it. You're riding our coattails, etc. And in this case, the plaintiff lost. The court dismissed the plaintiff's claims of trademark infringement, holding that Noom's use, as you see here, was in fact fair use. They took no more than reasonably necessary. They only mentioned Weight Watchers once. They didn't link to the Weight Watchers site. They made it clear in the context of the ad that they were comparing themselves to Weight Watchers and not suggesting that Weight Watchers had endorsed or authorized the use. So this is an example of nominative fair use defense carrying the day for a defendant. Slide, please. Often we hear about unauthorized dealers, distributors, and repair services using a trademark. In general, this is one where the nominative fair use analysis can be determinative. If someone is advertising a business using your trademark, but they're offering some ancillary service related to your product or service, it might be hard to shut it down because nominative fair use will often carry the day. There are 4 examples in your materials. One mentioned here is Toyota Motor Sales versus Tabari. I think this case is interesting because it shows that the nominative fair use defense also extends to domain names. In that case, the defendants were automobile brokers. They were not dealers, but they helped people to purchase Lexus vehicles, and they registered the domain name buyalexus.com. Toyota sued because it didn't wish to have its trademark Lexus used in their domain name, and it lost. The nominative fair use defense, again carried the day, and the defendants were able to show that they had a fair use interest in keeping that domain. Slide, please. Use of a competitor's trademarks in advertising is another way in which the nominative fair use defense can be relevant. Another party can use the competitor's trademark to make truthful claims about the competitor's product. Use of a trademark to make untruthful statements, however, can lead to confusion about source and can lead to liability. There are, again, multiple examples in the materials, but 2 I wanted to focus on here both involve Amazon.com, and I think they illustrate the difference, possibly. One of the cases is still pending. That's why there's a question mark there. We don't know how it will come out in the end, but slide, please. Talking about the first case, Multi-Time Machine Inc. versus Amazon.com. This one came out of the Ninth Circuit in 2015, and it's interesting because Amazon was sued and ultimately won. They were showing on their website, if you typed in Multi-Time Machine or MTM as a trademark, they were displaying competitive products that you could purchase in lieu of an MTM trademark They didn't sell MTM, but they sold other alternative products, and they ultimately won. The court held that because the results page clearly showed the name and product of what you were actually buying and not MTM, that this was a fair use. Slide, please. To contrast, Amazon is the defendant in a second suit, this time filed last year in the Northern District of California by Williams-Sonoma, where it's not looking so good for them. They moved to dismiss, and the motion to dismiss was denied. The suit is currently pending. Williams-Sonoma, the famous retailer, complained about several practices of Amazon. One of them involved, products that were legitimate Williams-Sonoma products, but that were being advertised resale on Amazon for significant markup. Separately, they complained about copies of their furniture, and we'll see where this case goes, but again, not looking as good for Amazon as the first case. Slide, please. Briefly, gripe sites. These are third-party sites where your brand is incorporated into a domain name such as yousuck.com or yourbrandsucks.com. Unfortunately, these are often allowed, especially if the website is making critical commentary or complaints about you. A registrant cannot register a YouSuck domain name just to extort the trademark owner into purchasing the name from the registrant. They also can't do it solely to direct business to your competitors, but if they're just doing it to comment about you, even if it's negative commentary, that's usually allowed. Slide, please. The last thing we'll talk about briefly is parody. This comes up a lot of interesting parody cases out there, just a few highlighted on this slide. On the right, this is one of the ones where the parodist actually was successful. It's an older case, but Mattel sued an artist who had a number of very interesting uses of Barbie dolls in his artistic works, and all of the works had Barbie in the title, so they sued for trademark infringement and ultimately lost. There was no infringement there. It was a fair use. On the left, we have a case where the parodist was not so lucky. In DC Comics versus Mad Engine, Central District of California, 2015, DC Comics was unimpressed with the use of Dad incorporated into the famous Superman logo, and the defendant lost a motion to dismiss. Ultimately, the case settled. Then the case in the center is really interesting. It's going on right now. Jack Daniels sued the maker of the product on the left, which is a chewy dog toy called Bad Spaniels. Jack Daniels has appealed the case to the Supreme Court. So we'll see how that comes out, but there's a lot of overlapping issues related to parody, First Amendment, etc. Jack Daniels obviously is not amused by this parody product, but so far the defendant has been successful and Jack Daniels did not. Last slide, please. And then I just thought I'd finish because who doesn't love a cute puppy dog? But this slide just highlights 3 more cases that are pretty interesting, all involving Louis Vuitton. There's actually a lot of cases involving Louis Vuitton and parody defenses to infringement. Louis Vuitton is very, very protective of their pattern. As you can see on this slide, there's one case with the puppy dog chewing what looks like a little toy version of a Louis Vuitton bag. That is the famous Louis Vuitton versus Chewy Vuitton case where the parodist ultimately won. So the parody defense was successful. We also see a depiction of a My Other bag. Again, the parodist was successful. And then above that, this is a still from a Hyundai ad. Hyundai was sued for showing that luxury basketball in their car ad without permission, and they lost. So if you're left scratching your head a little bit, like what's the difference between the 3 uses here, you wouldn't be alone. And I think the bottom line for parody is, it's a complicated analysis and you never know going in necessarily how a case is going to come out. And with that, the fastest trademark presentation in the history of the West, I will conclude. It looks like there's no questions, so I will turn it back over.
Thanks,
Thank
Jamie.
you.
Mary will give us another CLE code.
Good afternoon. At this time, I will announce the third CLE code. Again, for those seeking credit, please type the 5-digit code into the Q&A box with your email and hit send. It is imperative to send your credentials and the code to receive credit for today's program. And if you need the attorney affirmation form, it is located in the survey link, also in the Q&A box. The third code for today is UHOLW. That is U as in uniform, H as in hotel, O as in Oscar, L as in Lima, and W as in whiskey. One more time, the third code is UHOLW. Thank you, and I'll turn it back over to our moderators to conclude the program.
Thank you, Mary. And that brings us to the end of the day. Thank you all for attending today's program. If you included your contact information with any questions that may have come up during the program and we weren't able to answer, we will definitely follow up via email. If you have additional questions that occur to you after this, all of the presenters' contact information is in the materials, and you're also welcome to reach out to Mike or I, and we will make sure that we get your question to the appropriate person, and we'll make sure someone gets back to you. Don't forget, in the materials and in the link you will be getting, that we do have a survey where we would like your feedback, and we would really appreciate anything that you are able to offer so that we can make sure we continue to do these webinars better each time that we do them. And last but not least, please don't forget to enter your credentials one last time before you log off so that we can track your attendance for today's CLE credit. Again, thank you all for coming, and we hope you join us for next week's concluding session, where we'll be focusing on more traditional termination and antitrust topics. Thanks, everybody.